7
ನಲ್ಲಿ ಇದೆಯಾ ಯಾರ್ದ
7 3 ಎರಡರಲ್ಲಿ ಲಿಸ್ಟ್ 2 ಎಷ್ಟೊತ್ತು ಕರೀತಾರೆ
ಅದು ಎಷ್ಟೊತ್ತಿಗೆ ಇರೋದು
ತೋರಿಸಿದೆ ಮತ್ತೆ ಲಿಸ್ಟ್ 1 ಆಗ್ಬೇಕಲ್ವಾ
ಅಲ್ಲ ಕೋರ್ಟ್ ಲಿಸ್ಟ್ 1 ಟು ಲಿಸ್ಟ್ 2:30 ಗೆ ಏನು ಇಲ್ಲಿ ಇದು ಕೋರ್ಟಲ್ 3 ಅಲ್ಲಿ ಎಷ್ಟನೇ ಮಾಡಿತ್ತು
3 ಅಲ್ಲಿ
ಒಂದು ನಿಮಿಷ
ಏನು ಗೊತ್ತಾ ನೋಡಿ ಲಿಸ್ಟ್ 2 ಟೋಟಲ್ 7 ಸೀರಿಯಲ್ ನಂಬರ್ 1 9 ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ
ಇರೋದು ನಿಮಿಷ
ಮೆನ್ಷನ್ ಮಾಡು ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅವ್ರು ಇದ್ರದ್ದು ಬಿಸಿ ಲಿಂಕ್ ತೆಗಿ
ಟೋಟಲ್ 7
ಅಲ್ಲಿ ಇದು ಹೇಳಿ ಲಿಂಕ್ ಹೇಳಿ
ಬಿ ಗ್ರೂಪ್ ಯಾವ್ದು ಫಸ್ಟ್ ಎಲ್ಲ ರಿಲೀಸ್ ಆಗ್ತದೆ ಅಲ್ಲ ಅವ್ರನ್ನೇ ಹೋಗುವಂತ ಹೇಳ್ಬೇಕು
734187 ಪಾಸ್ಕೋಡ್ 8845 CH-3
ಟೋಟಲ್ 3 ಲೇಟ್ ಬಿಡು
ಟೋಟಲ್ 3 ಲೇಟಾ
ಎಷ್ಟನೇ ಮೇಡಮ್
9 15
4ನೇ ಮೇಡಮ್ ಹಿಡಿಯುತ್ತೆ ಅದಕ್ಕೆ
ನೀವೇ ತಂದು ಕಟ್ತೀರಾ
ಇಲ್ಲ ಮೇಡಮ್ ಪಕ್ಕದ ಮನೆಗೆ ಇಲ್ಲಿ ಬಡವರು ಅಷ್ಟೇ ಮಾಡ್ಯಾರ ಪಕ್ಕದ ಮನೆಯಲ್ಲೇ ಬರೋದು ಸರ್ ಹೋಯ್ತಾರಲ್ಲ ನಾನು ಬರ್ತೀನಲ್ಲ ಅನ್ಕೊತೀನಿ
ಎಷ್ಟೊತ್ತ ತಿಂಗಳ ಇದು
ಇಲ್ಲ ಮೇಡಮ್ ಅದೆಲ್ಲ ಸರ್
ಸಾರಿ
ಆಮೇಲೆ ದುಡ್ಡಿಗಾಗಿ ಏನು ಗೊತ್ತಿಲ್ಲ ಇರ್ತಾರಲ್ಲ
ಚೆನ್ನಾಗಿ ಪರಿಮಳ
ನಿಮ್ಮ ಆಫೀಸ್ ಅಲ್ಲಿ ಮೇಡಮ್ ದಿನ 50 ರೂಪಾಯಿ ಕೊಡ್ತಿದ್ರು. ಇವಾಗ ಏನ್ ತಿಂದು ನಾನು ಮೊದ್ಲು ಕೊಡ್ತಿದ್ದೆ ಡೈಲಿ ಹೂವೆ ಸರಿ. ಇವಾಗ ಸರಿಯಾಗಿ ಕೊಟ್ಬಿಡ್ತಾರೆ. ನಾನು ಏನ್ ತಪ್ಪಿಕೊಡ
ಅದೇ ಅಲ್ವಾ 7 ಹಾಕ್ಬಿಟ್ಟಿದೆ. 3 ಲೇಟ್ ಅಲ್ವಾ? ಏನದ್ ಬೆಳಿಗ್ಗೆನೆ ವಿಡಿಯೋ ಶುರು ಮಾಡ್ಕೊಂಡಿದ್ದೀನ? ಯಾವ ಜಗ್ಗಿ? ಹಾ ಅವ್ನ್ಗೆ ಏನ್ ಸರ್, ಅವ್ನಿಗೆ ಎಷ್ಟು ಏಜ್ ಆಗಿದೆ ಈಗ ಹೋಗಿ? ಯಾರು ಈಗ್ಲೂನಾ?
ಏನು ಅಭ್ಯಾಸ ಇಲ್ಲ, ಒಳ್ಳೆ ತಾರೀಖ್ ತಗೊಳ್ಳಿ.
ಯಾವ್ದು ಬೇಕು ನಮ್ಗೆ? ಟೋಟಲ್ 3 ಇದೆ.
ಟೋಟಲ್ 3 ಅದರಲ್ಲೇ ಇದೆ.
ಇಲ್ಲಿ ಇದೆಯಲ್ಲ, ಇರಿ 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 ಇರಿ. ಮುಗಿಸಿ ದೇವ್ರ ಪೂಜೆ ಮುಗಿಸಿ. ಜಾಯಿನ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಪ್ರಾಬ್ಲಮ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ನೀವು
ಕೊಡ್ತಾರಾ ಡೇಟಾ ನಂಬರ್ 3 ಕೊಡ್ತಾರಾ
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅಸಲು.
ಇದೆ ಲಾಗಿನ್ ಏನು
My lord, fresh matters. Additional than a suspension. My request for Monday minutes on fresh matters. There's some urgency.
Let's see. Yes.
Madam, fresh matter, there is a execution pending in trial court, madam. Kindly list it on Monday, madam.
Any mentioning? List 1, page 1, serial number 1 to 4. Page 16, serial number 5 to 9. Page 17, 10 to 19.
CL number 10, my lord, for petitioner, praying for short accommodation, my lord.
50% pension.
Yes,
Yes. Just after all this.
Page 18, 20 to 25. Page 19, 26 to 30.
29, my lord. Appear for petitioner is given. Pray for short accommodation, my lord.
Yes, my Sorland workers. Who appears against you?
Government, my lord.
Workers absorption.
Yes.
Yes.
Page 20, 31 to 37. Page 21, 38 to 46. Page 22, 47 to 49. Page 27, 70 and 71.
51 and 52 minutes.
Huh?
51 and
The orders list.
230.
230 orders list.
Admission, list 1, page 1, seal number 1. Farina.
Appear for the appellant in this case, my lords. This is a suit for my lords infringement of my registered trademark and passing off. I am before this honorable court being aggrieved by the order dated 24/7/2024, where my lords despite me being
What is the order?
the order, my lords, is found at page number 34 onwards. Just to give a background, my lords, I started using this trademark in the year 1992. The defendants, my lords, claim to have proposed to use from the year 2008 onwards. I am the prior registered owner. I had filed numerous citations, my lords, to also show how there's an infringement and passing off. While passing the order, my lords, emergent notice has been issued to the plaintiff while rejecting the ex-parte ad interim injunction. Kindly see, my lords, the ink page number 38 of my appeal memorandum.
Page number?
38, my lords.
Just a moment.
Please, my lords. Page number 38, my lords. In the section titled Order, it says issue emergent notice of IA number 1 and 2 to the plaintiff. And I've been asked to comply with the requirements of Section 12 of the Commercial Courts Act, despite the fact that I filed a request for ad interim ex parte urgent reliefs. And the only ground on which it has been held so is that I had prior knowledge and therefore I should have come under Section 12A. Fact of the matter is, my lords, I've been opposing the registration of the defendant's marks before the registry. I have taken adequate steps. I wasn't aware of the exact nature of the infringing activity until very recently, when a sale was made in Bangalore of the infringing product. So food product used by everybody from ordinary construction laborers to all members of the society who use coconut oil in their cooking. Therefore, Your Honor, the probability of confusion from the two competing marks, I am KLF Nirmal, they are Kirti Nirmal, both are coconut oil products. I've been using from 1992. Turnover is in the vicinity of several hundreds of crores. I have engaged celebrities as brand ambassadors. I've won numerous awards. All of that is supported by documents before this honorable court.
When is the order passed?
24/7, my lords. 24/7/2024.
What happened? Returned by 28, it was listed on 28?
Yes, my lords.
And?
We pointed out that the emergent notice was issued to the plaintiff itself and sought for a short accommodation. It has been adjourned, my lord. It's coming up on Monday next.
Take out notice, please.
My lord,
The notice to the respondent.
my lords, if I may just make one submission, my lords. In so far as, just on the merits of the case, my lords, I just wish to make two submissions. Kindly see, my lords, Annexure B3, which is found at ink page number 76.
Counsel, even now you are before the commercial court in the very same stage.
Please, my
These
lords.
are matters you can appraise before the court on the next date of hearing.
My lords, the problem, my lords, is that
Has now notice been issued to the
no, my lords, notice has not been issued yet. The reason, my lords, is because this appeal was filed initially as an MFA. Therefore, thereafter it was converted, my lords. That was the intervening period of delay because the process of conversion took some time.
When did you file the
Please, my lords. 14th August 2024 is when I filed, my lords. It was initially filed as an MFA.
is this an appealable order at all?
Yes, my lords, because it's covered, my lords, by under Order 43. Kindly see, my lords, Order 43, Rule 1.
R.
Sub-provision Q, my lords. My apologies, my lords, sub-provision R.
R.
R. And the appeal was ordered to be converted on 21/8/2024, my lords. 22nd, my lords, my apologies.
It has not passed any order.
It has not passed any orders, my lords.
Even now, notice has not been taken out to the defendant.
No, my lords, because of the pendency of the appeal, my lords. Because, my lords, the problem in this case, my lords, is that
Take
if
out
the
notice to the defendant, we list it immediately on the reopening day.
my lords, may I then request for a stay of the order, my lords, because it's posted on Monday. If the emergent notice is issued in this case, my lords, then I'll take out notice here, my lords, but the lower court proceedings may kindly be stayed.
The law. As a matter of fact, it is a case where you should be taking out notice there and pressing for the relief there.
My lords,
Instead of this appeal itself,
my lord,
as to how far the appeal is
I'll-
warranted in a case like this, we have our
I'll explain, my lords.
serious doubts.
If I can just maybe take my moments of my lord's notice. My lords,
Pass over,
this,
we'll hear it.
please, my
Pass over. Yes.
Seal number 2, Ketan Kumar.
It's defendant's appeal, my lords.
Yes, OD facility, term
Ex-parte.
loan.
Please.
5824 is the decree.
Please, my lords, it's
Yes.
ex parte order, my lords. I had only filed my
Notice,
meanwhile interim
sorry.
subject to deposit. I am willing to subject to deposit.
Yes, if you're depositing the
Please,
entire amount,
please, my lords.
yes. Will be a stay of proceedings in execution on condition that the appellant deposits the entire decree amount with interest before.
Not
this court.
entire. Subject to,
75% of the decree amount with interest.
please, my lords.
Yes. Within,
My lord, this is a case of
yes. Before the trial. Yes,
3, Narayan Bhatt.
appear for the petitioner.
with the mandate for auto renewal. Yes,
My lord, this is a case of transfer. My lord, the petitioner was working as additional director, my lord, in Lalbagh, Horticulture Department. My lord, she has been transferred, my lord, to the Revenue Bhavan. My lord, as additional deputy commissioner in Bangalore. My lord, from a post in Bangalore to another post in Bangalore. My lord, that is not the
the tenure was, you
Tenure
first appoint,
first, my lord, is in
Posted as
July
post
22. Then, my lord, immediately she was transferred before completion of 3 years. At that point of time, it was
not
3.
immediately on 22/8/23.
That is after 1 year, my lord. 1 year,
that
1
was
month.
set aside.
Yes, that was set aside.
16/7/24 after completion of the tenure,
After-
which have now been transferred.
Yes, my lord. My lord, the controlling department, my lord, has recommended that she may be retained.
That has been considered, counsel.
My lord, that is not considered, my lord. That's why, my lord, the reason behind this transfer is, my lord, she was a part of an investigation team,
Hmm.
my lord, which unearthed, my lord, the fraud of several crores.
Hmm.
And my lord, immediately after transferring this petitioner, my lord, the suspension of that officer is revoked.
Hmm.
My lord, it was a misappropriation, my lord, of about 3 crores. My lord, the office,
Where do you say all this?
my lord, I have stated, my lord, in para. My lord, para 7 at page 7.
In your application before the tribunal?
Yes, my lord, I have stated that. My lord, page 25, my lord, your lordship gets that. In detail, I have made a reference. My lord, my small prayer is, my lord, I have requested your lordship to summon 4 files. Page 25, my lord, I have stated in detail.
Yes.
Tenure is completed. She is a KS officer, Karnataka Administrative Services. It's a deputation post to Horticulture Department.
Yes.
My lords, after the tenure is complete, the fact, my lords, that she is part of the investigation team, we have taken action on the basis of that. And they're trying to create a ground of malifieds on the basis, my lords, of some other thing. If a statement has to be filed, we'll file, my lords.
Yes, please do. Learned government advocate takes notice for
1 to 5.
1 to 5. Notice to respondent for this. 6 respond already
My
notice.
lord, already caveat has been filed.
Yes.
Six respondent I have.
Yes. List after holidays.
Please,
Pleadings, if any, shall be completed by then.
please.
Please place it on record.
My lord, during the pendency, my lord, at least casual leave may be granted to me, my lord. Otherwise, they'll treat me as an unauthorized absent.
One
Your
kilo.
contention is that it is malified.
Yes, my lord.
We are considering
We'll
the transfer is to another post in Bangalore itself. Please go and join them.
One-
We'll
It's
consider it
1.5
on the
kilometer,
minutes.
my lords.
Please.
Lal Bagh and near civil court.
Please go and join. Yes.
Please.
30th,
My lord.
30th October. Preliminary hearing, number 4, Sumananakana.
In 4.7, I have to make a bit of reply with permission of the court because that day I was on my legs in another court. My senior friend has
Government
made
will not watch the-
submissions. I would request a few submissions, this is for about 5-10 minutes. Sir.
Not government was supposed to not make a submission. I don't know.
as far as the government is concerned,
I was not heard as reply in that matter.
my lord, I'll submit on Monday, my lord,
madam,
because the ACS was not available, my lord, for
My
Giving
submissions may be
instructions.
heard.
so he has said that tomorrow he will come and give me instructions. My lord. Monday it may be taken up. I'll take.
Lords, I'm for the
In the meantime, my
respondents.
lord, my lord, we kindly.
Monday.
It's the last day before court, not breaks.
Our applications for restoration may kindly be heard. I have to only reply for a few minutes. That day I was on my legs. I couldn't reach in time.
I have no objection for that, not some document is now given saying that they finished the bank.
No, we are not furnishing any new document. It is the meeting which they held. Unanimously, they decided that day. That fact, I am bringing it to the notice of this honorable court by getting the details of the fact that there was a meeting. They also referred to the meeting in their termination, that order which they have furnished. Therefore, I would just point out what it is, and if your
But
lordship kindly
I
gives me
quite see, my
permission.
lord, my handicap is some papers are given to me now. I'll just take instructions, my lord. If it's anyway going to go on Monday, my lord, I will not take time. So I don't know what these are.
We'll make an attempt on Monday.
Please, my lord.
But I am requesting,
Is there anything else on 2:30 on Monday? 2:30 Monday.
Please.
this could be
One
taken
request,
up.
my lords, before
Even
your
if
lord.
Priority first, please, because I need to be heard on this, my lord. I need,
Council, you will be heard.
Please.
The question is whether we'll be able to hear you today or on Monday because of the paucity of time.
since he
Let
has
us-
sought for time, I don't mind Monday.
Yes.
Please.
Please, my lords, could I make one request, my lords?
Yes.
I'm for the respondents' original writ petitioners. Lordships may kindly call for the records, my lords, of WP 11357 of 2017, because a number of documents that we rely on, my lords, for our case for absorption are not before your lordships in the record. That is the
Inspection
record of the
records may
learned
be
single.
ordered to be put up.
In the order.
Kindly ask.
Please.
Grateful.
Yes.
So grateful.
Yes, Monday.
Yeah.
Monday 2:30. Monday 2:30.
Yes,
Interim orders.
original records of the writ petition.
My lord, we have served the copies of the whatever documents we have referred. For with permission, can we place it on record? Because if we file it in office also, it won't be put up because the file will be here.
Yes,
Interim orders to continue.
yes.
Monday, 2:30 minutes.
Monday at 2:30.
Grateful.
Obliged.
Five, Nagendra Kumar K.
Kindly pass out, my lord. Senior is held up.
Just a moment. One annual increment. Application has been dismissed. Learned government advocate to get instructions list after holidays.
6, government advocate.
Yes, this is the
Yesterday's
case of the two
matter.
notifications.
Lords, in fact, I will just state, my lords, what transpired on the last date of hearing.
Yes,
Lords, that was on the last date of hearing. In fact, my lords, after appointment was given to the petitioner herein, the third respondent herein, Lords, the petitioner's case was considered, and then, my lords, the direction of the tribunal was only to consider her case insofar as operation of the additional list. But that was over after a long lapse of time, my lords. For some reason, my lords, decision was taken at the state government level, my lords, to give her an appointment order. Now, my lords, we created that situation, my lords. There is no two ways about it. Facts speak for themselves. So therefore, my lords, at that point in time, court also felt that something had to be done because there were two people who had to be accommodated. Now, I had made a submission that we will see. Supernumerary post issue came up, but then there was a fight between both of them as to who will become supernumerary and who will become the regular. So at that point in time, my lords, the director was here. So we had made a submission that there seems to be some vacancies. If it could be a court order, we will just place that on record is what I had submitted. The then director, my lords, who was there before the court and who had instructed me had retired. So therefore, yesterday I had to take instructions on that, my lords. Now they're coming with a vacant post list. If a vacancy is available, since it's a backlog vacancy, if my lord could pass an order with regard to the vacancy and, my lords, with regard to adjustment of that reserved post, my lords, in future recruitments, because that reservation point has to move. Because I'm yet to get that position, my lords. Can it be at 2:30, my lords, may dispose
If
it.
as a matter of fact, does that give a quietus to the entire?
It will give a quietus, my lords. But only thing is with regard to
No, what we'll do is,
Please,
as a matter of fact, as an interim measure, we'll say that she should be accommodated.
no, my lords, it could be
And
disposed of
then-
today itself is what I'm saying. For this reason, my lords, if in fact we had not challenged the order, my lords, that was passed in favor of the third respondent. We had not
Correct.
challenged. Contempt was filed.
Correct.
My lords, contempt was filed, and we had stated the other person filed a review application. Review application was dismissed. Then they came before this honorable court. This honorable court passed an order. I should not relieve the person. So we made a submission before the court that matter is pending in the High Court. There is an order. I'm
Understand. There
At
is-
that stage-
As of now, it is because of the interim order passed in the other person's case that you could not give effect
No,
to the.
I
to
could not
the
give
order.
effect, my lords, but
Contempt, we understand.
no, therefore, at that stage, since we were at the stage, my lords, where charges were about to be, we were, instead of challenging the contempt order, I had to challenge the original order. We challenged the original order, came before this honorable court, and then, my lords, this honorable court, my lords, gave me some relief, my lords, insofar as the contempt was concerned. But the issue had to be sorted out. Now, my lords, if vacancy list I'm yet to get, we'll get it now, my lords, today itself. If there are vacancies, my lords can dispose it off, my lords. They have given a synopsis. It could be disposed of. Now it is not. If it is supernumerary, then there will be an issue about who has to be. Both are above 40. And I've taken instructions from the department. The new director has come. They are also considering, my lords, both are above 40 in fresh recruitment. Both can be accommodated. I have vacancy. Only thing is I want to get the vacancy portion, place it before my lords. Today itself, final disposal can be made, my lords, at 2:30. Please, my lords. In fact, with supernumerary, it
Understand.
became
There is a
an issue
difficult-
between both of them.
Yes, yes.
Let me, for the last, I've been
No,
working
today
for
it's a-
7 years. I'm out of post, out of serving.
No, final order is what,
Today
today itself it could be disposed of, my lords. I'm saying
Yes.
Accommodated.
2:30.
2:30 minutes.
7, be contemplated.
Lord, sanction of 15 years time.
834 under challenge.
Please, no.
15 years TBA rejected.
Matter was considered by your lordships.
8 stagnation increments.
My lord, the content eats stagnation, not the two contentions I have taken. Rule does not say, my lord, that stagnation should not be reached. Produce the copy of the rules also. Number 2, my lord's representation is made. My learned friend, my lords,
From
took
the
time to,
minutes.
my lords, secure instruction because I made the representation, said I have not.
We'll file our objections. We have taken time to file my
So
objection. The reason
Can the representation be considered?
representation
accord-
will be considered.
Can it be disposed of on those grounds? It can be done. Otherwise, the issue with regard to how.
Because there is a dispute over the fact that he has reached the maximum
Correct.
time scale of pay. That
But
representation
two
may be
counts,
given.
otherwise, my lords, I mean, if they come up with the same endorsement again, my lord, again I'll be
List after all.
immediately after my lords, the vacation. Lordship may indicated 8 months. So
30th,
published.
8, Parshuramayan.
For the petitioner.
Answer key corrections.
If the word is matter properly, because what the tribunal what has said that challenge to the uncertainty at this stage is not maintainable. On merits, it is not being disposed of. The logic or inclined to send it to the very back to the tribunal
No, not in.
for a consideration on merits.
Madam, for respondent number 3, my lord, kindly pass over, madam, because of senior is in his portal 1 is held up, my lord, please.
So if my lords may recollect, it was dismissed on the ground.
Answer key is disputed.
Answer key is disputed.
Final answer key is disputed.
Answer key. This was that PSA recruitment where my
Whatever
lords,
the recruitment, if it is being considered,
please, my lords.
if it's not considered at this stage,
No,
then
therefore,
what
my
would be
lords,
the
in
purpose?
last date of hearing, if my lords recollect, I also made a submission. At any point in time, it has to be considered.
Correct.
There is no point in considering it after the final select list is out
Correct,
because
correct.
again, if there is the intervention at the hands of the court,
Immediately.
I have to read it. I have to redo the whole list.
Correct.
Then third party rights will intervene. So
Correct.
therefore, in fact, I made a submission that KEA could take instructions, and if it's only about 6 answer keys, instead of remanding the matter back, because now my lords, so
Fair
let
enough.
them. That is what.
Please have instructions.
Kindly pass for my, please.
No, my lords.
Will I-
I am told NK Ramesh.
Whether you have instructions.
They have no instruction. NK Ramesh, my lords, called me. He says they will file a statement of objections in this matter, and it could be maybe immediately on 14th, my lords, on reopening.
Meanwhile, they are not going
No, my
ahead
lords,
with
the stage is this, my lords. In respect of question paper 1, this is question paper 2. Question
Correct.
paper 1 was a essay type where my lords
Correct.
tribunal disposed it off.
Yes.
Thereafter, my lords, the merit list has already come to the state.
Hmm.
On the basis of merit list, my lords,
So it is for you to act.
provisional select list is there. Then medical is there. So there is no medical is yet to take place. Then objections to the provisional list. So final select list will at least be a month. So in the meantime, it could be heard 14th or 15th, my lords, in case.
Then go on with the process. Final appointment orders may not
Will not be.
No, it will not. I don't.
It will not be.
I think 15 days, it's not even possible.
Yes. Learned government, learned additional advocate general on behalf of the respondent submits that the selection is ongoing and that there is no chance of any final select list being issued during the course of the month.
During the course of
the month.
However, other things we are
List on
going.
15th.
Please.
Nothing else.
Please.
It's only saying that and if the final list doesn't come.
Please. Then no problem,
Probably
because
get
it's only provision.
15th.
15 to that.
Okay.
Okay.
Yes,
Please.
please see that the
Please.
meetings are placed on record. by
Please.
them.
Please.
Okay.
Lords, I have one thing to bring to my lord's notice. There's one more now after this petition got disposed of. There's one more petition filed on this issue with regard to the same questions before the KT. If my lords itself consider this, my lords, that will become infant. Just wanted to bring it to my lord's notice because on that day, my lords, one advocate made a submission that we have now filed it before. These people had gone when the key answers, my lords, had to. So this petition itself could be considered, is what we are saying.
If
There's
it is
one
the
more
same, if it is the same questions that are
My lords, therefore,
in that also,
in the
otherwise may have to.
I am informed, my lords, that it includes the same question plus additional questions. One matter is pending before the KAT. But still, my lords, what happens is the key answers were issued, my lords, I think 6 months back, I think, when the results were announced. Now, my lords, there was a litigation on some other question paper 1, which got cleared.
Correct.
So can we make an application to get that here? Because what happens is this.
That may be
If
better.
key answers is decided there, let us assume one way or the other. Again, second round of litigation here. It's only a question of 7 or 8 key answers. And I will file an application here itself so that I can get it on.
Correct.
Please, grateful.
Please.
9, Satish K.
Physical education teacher, PCM Kannada, 4723 suspension, 10(1)D arrest and detention. 2011-23 articles of charge issued. 24-11-23 charge sheet issued, A29. You are accused 29. 10(5)B not applicable. All it is.
On
Yes.
the last occasion, your lord.
The urgency is your urgency is that you want a stay of the suspension. May not be possible. Articles of charge are issued. The charge sheet in the criminal case also listed immediately after. 30th.
Government's case is that they have been appointed against a vacancy which was not available. If they can show that they have been appointed against a vacancy which was
Therefore,
available.
the
they have
criminal case as well as the disciplinary proceedings are ongoing. In that, you will have to, because it is not only a question of suspension, it is a question of whether there is your appointment was proper or not. Have to be decided. Yes, after all.
Then adjourned 11, Vijay Simha Reddy. Vijay Simha Reddy.
Question is only with regard to the diasnon. Now it is only diasnon. Compulsory retirement has been
11.
after holidays.
30th. 12, Suresh D.
SLAO KIA DB relieved on 30/4/2024 on complaints.
This, you were originally appointed to the KIDB. Then after she is appointed in the KIDB, it appears that she was given a enhanced position of SLA. This above her on delegation. She served there for some time. Then it so happened that there was some tussle within inside between her and the officers. Page number 22. This is the original order of posting. A1 page 27.
We've gone through the, we've gone through the papers. It appears that, well, the contentions have been considered. Can we have this immediately after holidays?
But when the issue is for about 1.5 years without the job, at least a salary could be paid to by the authority. It's by default.
She's not been given a posting order?
Anywhere. Salary is given. That they cannot deny.
What do you say? She's been only repatriated to the parent department. How can you deny posting?
And one issue not is the undersecretary to government put me into the KDB. But the secretary to the KDB has put me back to the parent department.
But that appears to have been considered by the
Yes, ma'am.
tribunal. Whether on complaints, the borrowing authority can say we don't want this person. That apparently is possible.
But they cannot keep me in vacuum.
Correct.
Repatriation is to KAD.
At
They
least
put
for-
on notice, R2 is on,
R2 is
Yes.
R2 is.
R2 has appeared. At least till the next date of hearing. By the next date of hearing, that will give me my salary. KIDB should make good my salary.
Where is the KDB?
In fact, even I have sought instructions. Madam.
Yes.
Now, in between government and KIDB, who has to pay the salary is the question.
Learned counsel appearing for the KIDB to get specific instructions as to learned government advocate as well as the learned counsel for the KIDB to get specific instructions as to the posting orders to be issued to the petitioner and the payment of salary to her. She, okay, to her. List on the next, immediately on reopening for 14, 15, 16, one of those days.
15,000.
16?
16,
Please. Okay.
13.
Petitioner in this case, my lord.
Council item 11, we have listed it immediately after holidays. The question is only with regard to the dice known between the compulsory retirement.
I'm sorry, my lord, I could not.
Third.
I'm for the
Yes.
petitioner in this case, my lord.
Yes,
In this case, I sought
Executive
for
engineer.
consider the representation, my lord, for the promotion that I faced a inquiry, my lord, that penalty order was passed by the court. Challenged the same, there was an interim order by this honorable court, my lord. During the time promotion, in similar circumstances, my lord, who have faced DGO, who have faced the similar inquiry, as considered for promotion and he is promoted, my lord. In my case, it was not promoted, my lord. In KT also, in another case, my lord, who is DGO in my inquiry, joint inquiry, is allowed and considered, my lord.
If identically situated persons who are also facing inquiry, they have been considered for promotion. Why is it that the petitioner is not?
Get
It's not
instruct-
only with regard to consideration. The reason stated was that there is a proceeding pending.
But I have to get instructions in this.
Please get specific instructions. on
Please.
this. Shall we have this in the reopening week?
I'm sorry, ma'am.
Shall we have this in the reopening week?
Please, ma'am.
Learned government advocate.
One day after the reopening.
Yes, yes, reopening week. Learned there are only 3 days in the reopening week though.
22nd.
22nd.
Please. get-
Learned government advocate seeks time to get instructions in the matter as to whether co-accused along with the petitioner have been considered for promotion or for additional charge.
Please.
list on 22nd.
14, government advocate.
Lord, in this matter, pray for,
Ending of past service. 224B.
pray for some time in this matter, my lord. I have to
At
get some
the
instruction.
request of the Learned Council, Learned Government Advocate, list after holidays.
30th. 30-10. 15, Achari Manjula Vit.
My lord, appearing for the petitioner in this matter, my lord, against the not granting the interim order, my lord, I have filed this risk petition. Since the main application become disposed of, my lord, it may not come.
It is submitted by the Learned Council for the petitioner that this writ petition was filed against the non-grant of interim order in the main application. Thereafter, the main application itself has been disposed of. The above is the matter, nothing survives the consideration. The writ petition is closed as having become infructuous.
Please.
16, PB.
Additional Deputy Director, suspension. When was charge handed over?
My lord, the incident is stated to have happened on 9th February. The
Charges
allegation,
handed over?
the allegation is that I have handed over charge on 9th, but I have done some work on 10th. Actually, my lords, I have handed over charge only on 12th, and that 9th date mentioned in the CTC is an error. I have placed e-file before my lords.
Just a moment, just a moment. Do you have instructions in the matter?
But not yet, ma'am.
Can we say something? This issue will be considered. Your specific contention is that you handed over
I
charge
handed over charge
only on 12. And if that be so, the only contention is that not that you passed any order, that you forwarded a file. That is all.
That's all, my lords.
Therefore, that can be considered by the question of revocation can be considered by them, considering this specific issue. This is a question of fact which it may not be possible for us.
Kindly do this. No, my lords, 3 months period has lapsed. Ajay Kumar Chaudhary, my lords, the order of suspension is dated 5th June 2024.
Correct.
Now, my lords, more than 3.5 months to 4 months have lapsed. My lords may direct revocation of suspension. That is the because
Will direct a consideration of the request for revocation of suspension. If as a matter of fact, your charge was handed over only on 12, then it will be
what
revoked.
the Supreme Court said in Ajay Kumar Chaudhary is this. Within 3 months, if they don't issue a charge sheet, they have to revoke the suspension.
That was on the basis of the rules, CCS pension, CCS rules which said 3 months. Here the provisions, here the provision says 6 months.
Here the provision says 6 months. But one month, as early as in the year 1965.
Correct. We are aware that it cannot be for a suspension, cannot be just for the asking.
And in fact, the government of India in the instructions based on Santanam Committee report, it has said that pre-charge sheet suspension should not exceed 3 months.
3 months.
And total suspension, including post-charge sheet, it is 6 months. But 6 months is little tall order, maximum around 7 to 8 months, it has to be done. Now the event is of 9th February. They keep me under suspension on 5th of June.
Yes.
Thereafter, my lords, now 4 months have lapsed almost. This is a case, my lords, where they have to, my lords, let them review the suspension and let it be called on revoking. Because I am
direct the consideration of the issue of revocation within 3 weeks. Within 3 weeks, consideration issue of revocation shall be considered within 3 weeks. If as a matter of fact, the handing over charge is only on 12, suspension shall be revoked.
Then my lords that may be an interim order because they don't review. That is my experience with this statement. Then I have to go and file a contempt. Contempt will take another 4 months.
Third, the learned senior counsel appearing for the petitioner as well as the learned government advocate appearing for the respondents. The learned senior counsel for the petitioner specifically submits that the petitioner had been transferred on 9/2/2024.
By the order served on me at 7:45 PM.
And that the order of transfer was served only after office hours on 9/2/24. It is submitted that the CTC would show that he had actually handed over charge only on 12/2/2024. It is submitted
It's
therefore,
read with e-file, my lords, e-file.
CTC read with the e-file. It
Read
is further submitted that since the handing over charge was effected only on 12/2/2024, the act of the petitioner in having forwarded a file to the deputy commissioner without anything further would not be a reason either for initiating any disciplinary proceedings against the petitioner or for suspending the petitioner from service. Though the learned government advocate had sought time to get instructions as to when the charge was handed over, no such instructions are forthcoming. In the above view of the matter, there'll be an interim direction to the, who has to consider?
To the first respondent, my lord, the secretary DPAR.
Second respondent.
There is the first respondent, second respondent.
Second respondent. There'll be a direction to the second respondent to consider the request of the petitioner for recalling the order of suspension
Dated
the-
5/6,
dated 5/6/2020,
annexure EA9.
taking note of the specific contentions urged by the petitioner. The request shall be considered by the second respondent within 3 weeks
Please.
from date of receipt of a copy of this order. After notice,
Not,
hearing,
no, not necessarily.
not necessary,
At the stage
within
of
3 weeks from date of receipt. The petitioner shall submit a written request for the same before the
Tomorrow,
second respondent along with a copy of this order.
Great.
Appropriate order shall be passed as directed above. List after a month.
Great.
5th November. 17, Satish K.
PDO suspension 29/2/2024.
This was ordered to second respondent.
Who's the second respondent? Jilla Panchayat.
Not appeared.
Why don't Jilla Panchayat secretaries appear? There are several matters. Jilla Panchayat does not appear unless this court directs appearance. What is this? They've been put on notice. Notice has been taken out, served to R2? No.
Yes, ma'am. Notice is,
Notice is taken
yes,
out
ma'am.
and served.
Lord, notice steps were taken up, Lord, on fifth September 2024. Lord, it was
Just-
dispatched.
Also on 13
Not served. List immediately after holidays, not served. Notice has been taken, not served and returned.
Because it is the order passed with
6 months.
lapsed.
It's passed by them.
It is passed
have-
by them, Lord.
Have to come.
This. That.
18, 30th.
Lord, interim order may be,
Matters to be.
interim order is there, Lord,
Yes,
till date.
shall remain in force.
Lord, I request the state matter to be called after vacation, my lord. My colleague is not well, my lord. He's
Commanded to retired on 30/6/2016. Penalty imposed after punishment, which is quashed.
after vacation. My lord, interim order may kindly be extended. It's until further orders, my lord, actually in the daily orders.
Further orders will be paid.
What was the penalty?
My lord,
What was the penalty? Penalty stands quashed.
yes, ma'am.
What was the penalty? No, because there is an interim order. No. it's not. It's Interim order. Coming for the first time. There's no interim order. This is coming up for the first time. Issue notice.
Sorry, my lord.
Yes,
Instructions by the department, what was this an interim order? I'm sorry.
there is no interim order because, yes, the application has been allowed. Penalty has been set aside. Please.
19. Vijay Kumar,
Disposed by the tribunal. 19, I'm sorry.
19, my lord.
Just a minute.
But benefit of age relaxation and
Pharmacist selection.
pharmacists and lab technicians. my lord. But the benefit of they were all appointed on contract basis, my lord, by the fifth respondent. But the rules were framed. But extending the benefit of age and, my lord, qualification relaxation to persons who are appointed on contract basis in the national rural health programs. But
What happened in the lab technician's case? It is,
Look.
it same plea has been agitated in the FOs.
But in respect of staff nurse, my lord, the benefit has been extended to the persons who are not included in the state sector by an order, my lord. Your lordship may kindly see page 4,
Plea in the present case is to.
481,
quash
my
the-
lord.
Just a moment, quash the notification in case of pharmacists and lab technicians. Grounds agitated is the same as a recruitment notification does not provide for age relaxation. Same plea has been agitated in the aforesaid application as well. It had been rejected, therefore. We are in agreement with learned counsels on both sides of cases completely covered by the judgment. Dismissed in terms of A 6074 to 6158. What happened there?
My lord, that is also under challenge.
That is
Yes.
pending here,
Yes, my lord.
already admitted.
No, it is still, my lord, they are yet to approach the court, my lord, but the writ petition is being preferred, I believe, my lord. My only submission is this, my lord, the benefit of relaxation having been extended to persons who are appointed on contract basis through the central government. But similar benefit also should have been extended to these persons, my lord. They are also under a scheme. But,
Gotcha.
yes, my lord. And a denial of that would amount to discrimination, my lord, and identical circumstances, my lord, this honorable court.
Whole scheme of giving weightage was contemplated only for the purpose of the those who were on
Appointed
contract
on
basis,
in state sector.
state service. Therefore, it cannot be said that they are working on their
They're, as a matter of fact, doing the very same work.
Yes.
It is not for anybody else that they are working for, it is a public
the
employment,
central government
though it
scheme
is
being,
under a scheme.
it is only it being a sponsored scheme. If the government appoints all of them under the state services, it will become difficult to accommodate them, my lord. They are not working against sanctioned posts. They were appointed only for that particular scheme.
Take notice, we'll list this immediately after holiday.
Similar benefit has been extended to staff nurse, my lord, who are
But in
appointed,
case of staff
that are
nurse,
produced.
there is
There were
divergent,
vacancies available also.
no, there were divergent opinions, my lord. There are
Yes,
several
yes, there
matters.
are petitions that the state has filed in the case of staff.
There are
nurse.
two divergent.
Lord, there is a
opinions.
direction issued by this court, my lord, directing that the staff nurse appointed on contract basis by the central government also should be considered and extended that benefit.
The
That is the
contention that
divergent
there
view
is-
by another
there is
division
Another
bench.
view by another bench.
Please.
Anyway, please get instructions on
But-
the matter.
My submission is this, my lord, the process of selection is yet to be completed. Some sort of a protection, my lord.
Action can be granted in.
And let the
Matter has
selection
come
be
for the
subject
first
to,
time. I will get
Yes,
instructions.
please get instructions. List it immediately after holidays. Let us.
let there be some sort, my lord, like subject to pending writ petition, the selection process, my lord. They will take their own sweet time, my lord.
Subject to outcome of the.
Yes. You're passing such an order without hearing anybody who's going to be affected by it. Yes. List it immediately after holidays. Please, on that date, we'll see.
Please.
What needs to be done.
Date, ma'am.
Yes, yes.
Date, ma'am.
Date immediately after.
24th. 20, Rajshekar, yes.
Yes, this is the case.
Please.
It was posted to 19-9. What happened?
19th 9 government advocate took time and it is posted to
In every case, my lords, I am facing this, my lords, there. Wherever I don't get interim order, my lords, they take adjournment.
What was the?
My lords, only short
issue
point is,
here?
my lords, the annexure A7 may kindly be seen. They refer to the, my lords, incident said to have been taken place on 3/6 and 5/6. Even according to them, my lords, they have issued show cause notice on 1/6, which, my lords, cannot be, my lords, is my respectful submission.
1/6?
Yes, my lords. Kindly see annexure A7. Even according to them, the alleged incident took place on, my lords. That too, my lords, submitted a leave application, my lords, to the higher officials. Page 48 minutes. Lords, kindly see page 50, my lords, in the first sentence itself, my lords, in page 50. Second paragraph, my lords, at page 49. They say, my lords, I have submitted though I was released from the duty on 5/6/2024, I have submitted the leave application on the next day, that is on 6/6, and again on 11/6 by, my lords, without following the procedure. And sent it
Submitted the revised leave application.
on
from
11/6.
Day 6/6 to 11/6.
11/6.
Without sanction from senior authorities, this petition is filed in the office of the district family health officer. Said employees relieved from duty forwarded here. This shows misconduct and disobedience. On 11/6/24, another leave application is
Another
again
leave-
submitted.
Yes.
Registered post. The said application has been returned to the employee's home address, and since the employee cholera control team is not working, a show cause notice
Show cause notice dated 1/6.
must be 11/6. Must be a mistake.
My lord, sir. Say when they are suspending, pending inquiry, suspending me.
This is the order of suspension.
This is the order of suspension. They are suspending me from, my lords. And in addition to that, my lords, I have produced one document which shows that, my lords, I was on leave from, and my leave was sanctioned.
What is the date of this order?
This date is 31st August 2024. May I request my lords to kindly turn to page 46 for a moment, my lords, page 46. I can understand if they have not sanctioned my leave and then I remained absent, my lords. Yes, kindly see, they have only stated in box, my lords, Nana is so-and-so, commuted leave. Date of leave period, 6/6/2024 to 20th June 2024.
Lord, I'll take instructions, my lord.
Can this be? If the leave is sanctioned, then what dereliction of duty? Then the dereliction of duties, if the facts are true, it is on the part of the person who granted the leave.
My lords, subsequent to that, my lords, I was on deputation. Then, my lords, my deputation was cancelled. Thereafter, the principal secretary, my lords, because the reason why, my lords, I was deputed there is, my lords, it is the constituency of the Honorable Chief. There, my lords, because of cholera, my lords, the disease, they wanted to, my lords, relieve me from that post. Then again, my lords, the principal secretary has passed the order directing all the officers who were on deputation to be continued there. This is the order of principal secretary. Now the district health officer passes this order. Director of health.
It was listed before the, if these are the grounds. Why is it not being, whatever you have to state, if you state before the tribunal by this time, this would have been decided one way or the other.
We shall do so before the tribunal only, my lord.
When is it listed before the tribunal?
110, my lords. Now they will file objections, then hearing, my lords, then in the process, my lords.
No, we are short circuiting the proceedings of the.
Now, my lords, I can
tribunal.
understand if there is any dereliction of duty on my part. They have sanctioned my leave. And, my lords, they say you have not followed the procedure to apply for leave.
Lord, on 110 before 110, we'll take instructions and submit before the AAT only. I shall
Just on 210.
210 is.
210 is holiday.
I'm sorry. 110 is the last day.
110.
My lord, we shall instruct the government advocate there, my lord,
Please
to
see
go on
that
with
it
the
is-
matter on the merits of
See
the
that
case
it is
and not take time for objections. my lord.
Lords, on
heard both sides. It is submitted by the learned government advocate that the, that since the matter stands listed before the tribunal on 110, the government advocate will not seek time and that the matter will be argued on merits on that date. Yes.
May I request my lords on the same day here, my lords, if they take adjournment, I'll come back to my lords.
Then even then we may not be possible.
At least to 2:30 on that day, my lords, so that my lords.
Give a listing.
Lord, one copy of this.
Same
petition
thing
because
happened.
I'm not getting the file in the office.
I'll
One
serve
copy,
my-
if a copy is
Serve
served,
it
my lord, I'll
immediately.
immediately
serve.
communicate.
Please serve it immediately.
Please,
Yes.
you can understand if there is any dereliction and if I have committed any grave, my lords,
Two forums shouldn't be considering it at the same time as our only action.
since my lords, they have not considered my prayer for interim relief, I am before my lords.
Yes.
Hearing the NIA, number 21, government advocate.
Examination malpractice.
Matter was partly heard. I
Yes.
had requested for an adjournment on the last.
Yes.
My lord,
The issue. May I suggest this, my lords, since my lords said they will not take any adjournment on 110. With that observation, petition itself can be disposed of, my lords.
Of course.
Saying
Yes.
that, my lords,
The writ petition is therefore disposed of, directing that the matter shall be the question of grant of the main application or the question of grant of interim relief shall be positively considered.
Considered on 110.
Yes,
Obliged.
by the tribunal on
the office may be directed to upload the order.
My lord, either way, I will need the
Today
copy of the petition.
Please,
my lord.
please
think
give
my
a
lords,
copy.
Because I
see
have to
that today.
communicate the application number.
please. My lord, my respectful submission, the issue that arises for consideration is the nature and scope of the government's power as an employer to assess the suitability of the candidates based on their antecedents and characters
Yes,
to appoint. My lord, it's a well-settled position that mere acquittal.
what was the reason for your, for the action of the government?
My lord,
in
what has happened
finding
is,
that
yes, what has
it's not
happened
suitable.
is, they were selected, they were in the final list,
Hmm.
but their appointments were withheld because when the background verification was done
Hmm.
through the local jurisdictional police,
Hmm.
it was found that they were involved in malpractice in the written examination,
Hmm.
competitive examination for the appointment to the post of assistant engineers in the Department of Water Resources.
Hmm.
But some dates may be relevant, my lord.
Hmm.
I just provide the dates, my lord.
Yes, please.
My lord, the notification was issued on 22/6/2017
Hmm.
for appointment of AEs in the Department of Water Resources.
Hmm.
Then on 10/9/2017,
Hmm.
the exam in question was held.
Hmm.
And thereafter, my lord, on 16/10/2017,
Hmm.
a complaint came to be filed by one Dr. Muhammad Dawood,
Hmm.
and it was registered as crime number 140 of 2017.
Hmm.
Lord, this complaint was actually relating to appointment of teachers, malpractice in the appointment of teachers
Hmm.
to Moraji Desai schools.
Hmm.
Lord, on that very day, 6/10/2017,
Hmm.
Lord, in the written examination for appointment of teachers,
Hmm.
one candidate is caught red-handed
Hmm.
using an electronic device.
Hmm. Hmm.
Based on the complaint on that very day, my lord, a candidate is caught using electronic device
Yes.
in the examination for appointment of teachers to Moraji Desai School.
Hmm.
Lord, he reveals
Hmm.
the information relating to the others who actually provided. It is the device is supposed to be composed. It is attached to a vest, and it has SIM card and earpieces.
Correct.
And with that information, they were supplying answers.
As a matter of fact, the complaint and the registration of the crime is the basis on which the action has been taken against them.
Yes.
No doubt there. Once the complaint is not found to be maintainable and the crime is referred, then what remains for that action?
Lord, I'll take your lordship.
Yes.
It will become clear when I take your lordship to
Mm.
the, my lord, in fact, the tribunal has given only a direction to consider, my lord.
Mm.
But what I'm saying, the direction to consider is circumscribes the right of the government to consider the eligibility of the candidate only to the select list.
Mm.
Does not allow the government to go beyond the select list
Mm.
and also find out regarding the suitability of the candidates. But I have a decision of the Honorable Supreme Court which says that it should be left to the government to assess the.
Absolutely. Without the FIR, what is left for you to say? If you have anything else, if there are other criminal cases against them, absolutely, you can reject the applications, you can refuse to confirm them.
But what I'm trying to
with
drive at
regard
is.
to this,
Please.
if as a matter of fact, nothing remains, how can it be?
My lord, as on the
This
date of,
direction be
as on the
against-
date of
Hmm.
making the appointments, my lord,
Hmm.
they were found to be involved in this criminal case. There were
Therefore,
criminal
it
cases.
is it your case that if there is a complaint as or an FIR registered as on the date of the appointment, which is later quashed, set aside, referred, whatever, makes no difference because there is a complaint, that person, an FIR,
Please, ma'am.
not a conviction, your lordship.
The B report is filed.
No, we are saying that all that is there at the relevant time also, at best, according to them, that is not there. At the relevant time, it is no FIR as against them. The FIR was only with regard to the common crime. They were subsequently shown as accused in there. That was quashed by this court. Subsequent separate FIRs were registered.
Indeed.
That were referred by the B report. Then the only thing is, as on the date when they were appointed or when you took up the matter for verification, there was a complaint against them. Yes.
There was a FIR, my lord. They were in the.
FIR,
Yes.
FIR, a first information
Indeed.
report as against them.
Their integrity was under cloud, my lord. My lord, may I just reveal a little more information regarding what was the complaint, my lord? My lord, the person.
Information with regard to the allegation may not make any difference because
My lord,
it is not.
it will only take a minute, my lord. I'll only mention it in passing.
Yes.
My lord, of course, it cannot determine the outcome of this
Yes.
case. My lord, the reason, one of the prima facie evidence against them was that the persons who were actually supplying the information, who provided the device, they revealed that it was not only in this recruitment,
Correct.
but also in the earlier recruitment which took place on, that is 10/9/2017.
Correct.
In that exam also, we assisted some of the candidates. And these are the candidates 6 candidates, the respondents in this case, my lord. They were the beneficiaries of this malpractice. And it was also found that one of the candidates' father had transferred around 15 lakh rupees to the account of one of the accused persons. Now, my lord, indeed, that charge sheet has, insofar as these 6 persons have been quashed only on the ground, it was on a technicality, my lord. It was on the technicality that there are 2 different offenses and they could not be clubbed under one FIR.
Your lordship, I oppose at this peace council. Yes.
So on that ground, it was quashed, my lord. Thereafter, my lord, the tribunal, this didn't mean that the authorities were prevented from filing a fresh FIR against these persons.
Absolutely not.
So as on the date of the tribunal rendering its decision, their integrity was still under a cloud because the High Court reserved the liberty to the police to file fresh FIRs against these accused persons. My lord, in fact, it was only after the filing of the writ petition that the B reports were filed. But
No, subsequent to the disposal of the matter by the tribunal, individual FIRs were, as a matter of fact, filed.
Yes, ma'am.
Individual FIRs
I'll
were
just
filed.
give the dates, ma'am.
Yes,
Further
please.
dates, ma'am. Dates
Yes,
will make
please.
it very clear. Dates are very relevant in this matter.
Yes.
My lord, then on 4/7/11/2000, my lord, I mentioned 16/10/2017 as the
Complaint.
date of examination of the written examination of the teachers. Then on 4/11/2017, respondent added as accused number 16 to 21. It is stated in the remand in the judgment of the High Court where it is quashed. In the remand application, but I'm not sure that it may be correct, my lord. In the remand application, they normally don't add the accused.
Whatever, on 4/11,
So,
they were.
4/11.
This was your case.
Yes, ma'am. This
Yes.
is their case. In fact, it is their case.
Whoso-
On 4/11/2017, Respondents were added as accused number 16 to 17 in remand application, which was filed in the same crime number, which is 140 of 2017. Well, thereafter, the final selection list is announced on 27/9/2018. So, my lord,
Yes, the provisional list is announced on 28/2018 and final list
final
is
list on 27/9/2018.
Yes.
My lord, thereafter on 3/2/2018, it is their admitted position that they came to know because they were summoned by the police to give the statements. That is when 3/12/2000, this assumes importance, my lord, this date, 3/12/2018, because one of the grounds on which I'm challenging the decision of the tribunal is that they have actually claimed that their application was filed within limitation, which is not correct. My lord, this is the date. They came to know regarding the case being, they being arraigned as accused on 3/12/2018. Thereafter, on 11/1/2019, notification for appointments were issued. But the petitioner's appointments were withheld. And they say that they approached the concerned authorities saying that they are not parties to any criminal proceedings. Therefore, they must be also be issued appointments, which is not correct, my lord, because prior to that, already they have admitted that they came to know on 3/12/2018 when the police summoned them to the police station that there was a case pending against them.
When were the FIRs, as a matter of fact?
My lord, it is
registered
stated
as
in
against
the writ petition that they were arraigned as accused number 16 to 21 by the remand application filed in the same FIR, that is 140 of 2017 on 14/11/2017.
Now that stands quashed.
Yes.
14/11/2017.
I'm only mentioning those dates because this is when they came to know, man. So, but they claim that they came to know only in 18 when they were summoned by the police, 3/12/2018. Even assuming that, my lord. But then coming to the next date, which is 9/3/2020, permission is sought to array the respondents as accused in crime number 140 of 2017, and the said permission is obtained. This is what is stated in the B report. But there is some facts are really not clearly forthcoming, my lord. So permission is sought. It is said in the B report that they are sought to be arraigned as accused on 9/3/2020, and permission is of 9/3/2020, and on 10/3/2020 it is granted. Thereafter on 3/7/2020, report of the appointing report is given by the concerned police superintendent of police Davangere, that based on their background verification, it is found that they are involved in crime number 140 of 2017. But this is challenged. 13/7/2020 is the order impugned. But if your lordships will notice, 3/12/2018 is the date on which they came to know about the case. And in order to overcome the limitation, 1-year limitation, they challenged the communication by the superintendent of police. And in the limitation, they have said that it is not barred by limitation. But thereafter, on 21/10/2020, they filed the application. But even the appointments were issued on 11/1/2019. They file it beyond the 1-year period. Even if we take from the date of appointment, from the date they came to know, it is 3/12/2018. But there's one more thing. They sought the same remedy. They challenged the very same communication, even in the writ petition where they challenged the FIR. And one of the undertakings they give to the court is that no similar application or case is pending for the same relief. Now, this could have had divergent, or it could have resulted in. So there was a false affidavit filed, my lord, stating that we have not sought similar relief.
When was that filed?
The writ application was filed on 21/10/2020. Challenging 21/10/2020. May I just take your lordship at this point to the prayer, my lord.
And when was the writ petition?
Writ petition was filed on 27/10/2020. May I take your lordships to the prayer, my lord, in the application. Lord, for convenience, your lordships may kindly notice the statement of objections filed by the respondent, because both the judgments are side by side. Otherwise, they are in separate volumes, the application and I just take your lordships to page 113 of the statement of objection.
Page number?
113, the judgment of the High Court, where they challenge the FIR as well as the communication dated 13/7/2020 is starts, my lord. 113. Annexure R8. The lordships may notice the prayer, my lord, at page 115. My lord, this is for at paragraph 2, my lord. The proceedings have sought quashing of proceedings initiated against them in crime number 140 of 2017 by the Azad Nagar Police Station, Davangere, and also letter dated 13/7/2020 as per Annexure G. Your lordship may turn to page number 123, which is the judgment of the impugned judgment of the tribunal in this writ petition. The lordships will notice the prayer at page 126, my lord, in capital, all in capital letters. This is annexure. My lord, may I just read from the beginning. These applications are filed under section 19 of the Administrative Tribunal Act with a common prayer to set aside the impugned order bearing number so and so dated 13/7/2020. And they give an undertaking in both the cases that they have not filed any case for similar reliefs. My lord, apart from that, your lordships may notice that there is a prayer, further prayer for a mandamus. There is no representation given for the mandamus. They cannot seek mandamus unless they give a representation at all, ma'am.
Yes.
And in fact, the tribunal does not grant the first relief at all.
What is the first relief?
My lord, the first relief is the challenge to the communication, 13/7/2020. What the tribunal has directed may be noticed at page 138, my lord. Applications are partly allowed. The respondents are directed to consider the claim of the applicants for appointment in terms of the final select list within a period of 3 months from the date of certified copy of this order.
Yes, your lordship.
But there,
If I could. Yes.
well, right? My lord, I'll take your lordship through the judgment, my lord, because the High Court's judgment is.
They've seen all that.
Please.
We've seen the judgment.
Please.
Question is only this, what stands in the way of your consideration in the facts of this case?
Please.
Yes.
My lord, may I just point out a few things? My lord, one of the grounds I'm taking is on limitation, my lord. The first ground is it was barred by limitation. Only to save the limitation, they have challenged the communication, which could not have been challenged. And the communication also has been challenged in 2 separate cases, which could not have been done. And that fact have been, they have not only suppressed the fact, they have also filed a false affidavit saying that there is no similar case pending for the same relief. That is the first ground, my lord. My second ground is there is no representation given for seeking the prayer of mandamus, which is granted by the tribunal.
In every case of mandamus, does there have to be a representation? Does that not depend on what the mandamus sought is? What is the mandamus here?
Lord, mandamus is to give a direction to consider their case for appointment as per the final selection list.
There is a final selection.
Final
list
selection.
In which their names are included.
Please.
They have not been appointed. The direction is to consider in every case.
Lord, now what has happened is the government has not at all had a chance to even reply to them. If they had given a representation, we would have given a proper consideration to the representation. Lord,
Yes, we'll
that
consider.
is my second
Yes.
submission. My lord, apart from that, my lord, there is suppression of material fact in that. My lord, there is a lot of contradictory statements made in the application itself. I'll draw your lordship's attention to page 127 of the impugned order, my lord.
Yes.
Well, this is to substantiate on the question of limitation. The tribunal has misdirected itself because it has made a factually erroneous finding
Hmm.
on the question of limit, this one,
Hmm.
on the question of when they came to know about their involvement in crime number 140 of 2017,
Hmm.
page 127.
Hmm.
I'm referring to the statement of objections.
127.
Statement of objections.
Hmm. Yes.
Bottom of the page, my lord.
Hmm.
The third line from the bottom.
Hmm.
The applicant submitted that it was only on 3/12/2018 when they were called for recording the statement in crime number 140 of 2017 by Davangere Azad Nagar Police Station. They came to know that one Tipesh Nayak, who is accused in crime number 1, had stated before the police that the applicants also were involved in examination malpractice and have been listed as accused in the said case. My lord, I'll pause here and take your lordships to the finding, which is clearly contrary to their own admission. Lord, at page 134, about 6 lines, my lord. Later, your lordship.
Hmm.
Later, the applicants came to note that their appointment orders have been withheld in view of the communication issued by the 4th respondent. This is the impugned order, but this is not what they have claimed. Tribunal has misdirected itself on facts, my lord.
Lordship, if I may,
My lord.
I may request. Let him complete his arguments. He's arguing on his repetition. Yes. Hmm.
My lord, therefore, the challenge to 13/7/2020 order
Hmm.
was merely a ruse to overcome the limitation.
Yes.
My lord, thereafter, my lord, your lordships may notice
Hmm.
the false submissions or the contradictory statements made by the applicants, my lord,
Hmm.
which is noticed in the impugned order of the tribunal. At page 129, I'll point out 2 major grounds, my lord.
Hmm.
Page 129.
Hmm.
My lord, I'm stating this in support of my submission that they have not come to court with clean hands, and therefore they are not entitled to any discretionary relief. They suppress the fact that they were arrayed as accused persons in crime number 140 of 2017.
Hmm. Hmm.
But before I come to this, I just take your lordships through the High Court's order, my lord, just a small 1 paragraph,
Yes, please.
because the facts are clearly forthcoming.
Hmm.
Truthfully in the judgment of the High Court, my lord.
Yes.
The page 116, my lord, para 3, may read, my lord. Accused number 1, Tipesh Nayak, wrote an examination held at Davangere on 16/10/2017 in connection with the selection of assistant teachers to Moraji Desai School. The vigilance squad received credible information that accused number 1 had indulged in malpractices while writing the examination. Accordingly, the squad entered the examination hall, found accused number 1, Tipesh Nayak, using micro-ear device while writing the examination, and consequently he was arrested. During his interrogation, he revealed that accused 2 and 4, namely Pradeep and Raghavendra respectively, assisted him in writing the examination. During the interrogation of accused 2 and 4, it is stated that they revealed that on 10/9/2017, in the examination conducted for selection of assistant engineers at Bengaluru, they assisted the petitioners herein in the same manner. The police brought accused 2 and 4 to Bengaluru in investigation. Accused number 2 and 4 brought the police to the park in front of the MS building and told that it was the place where they had met and conspired with the petitioners to help them write examination. Subsequently, they took police to room in a lodge in Sahakara Nagar in Bengaluru and told them it was the place where they demonstrated an experiment to the petitioner, showcasing the manner in which they helped the latter to write examination. Therefore, based on this information, the petitioners were arrayed. But here they are admitting, based on this, the petitioners were arrayed as accused number 16-21 in the remand application dated 4/11/2017 17.
Hmm.
Investigation thereafter. My lord, this writ petition, as I pointed out, my lord, is filed in October 2020, and also the application is filed in October 2020. Just a week difference, my lord. Here they say that they are arraigned as accused in crime number.
Where do they say that they knew?
I'm sorry.
They're only stating a fact that they were arraigned as on this date. Where do they say that they knew about it? There is no contradiction.
They've said that they knew, they came to know. My lord,
Where?
my lord, on 3/12/2018, they came.
Correct. That is their contention in both the writ petitions. In the writ petition as well as the application. They were arraigned sometime in 2017. They came to know on 3/12. There is
Even if it is 3/12/2018, my lord, the application and the writ petition came to be filed in October 2020. Here in the application, they claim, my lord, at page 129.
Where have you raised such a contention?
Right.
Where have you raised such a contention before the tribunal? That it was belated. Counsel, all you have been directed to do is, now that these are the facts, the worst allegations against a person cannot do duty for something concrete against it. These are allegations. If what you appear to be telling us is that
But we have
your
contended
police
that-
cannot be believed.
My lord, we have contended that they have suppressed facts, my lord. That's that
Where have
contention.
you stated that it is belated? That the application. before the-
Delay, my lord. Round,
Raise such a contention, then why should the tribunal consider those contentions? Here at a stage where your police have conducted investigation and has issued these B reports, is it your contention that they cannot be trusted? Is that, now as a matter of fact, there is as on
my
today,
lord,
there is
my
nothing you can
contention
say.
is this, my lord.
If
My lord,
as a matter of fact, there is anything that you find in your verification, you can take action. You have the power. You cannot go on wild goose chases.
my lord,
It has to be something.
there is a
else against
specific
the person.
contention in the application as well as the writ petition that there has been suppression of fact that they were added as.
That by itself will not do. They have not suppressed it because they've also filed the application to quash the FIR on the ground that they have been roped in.
Yes, on the one hand, they say they are parties to the FIR. In the writ application, my lord, this is what they are saying. Application submit that they are not arraigned as accused in crime number 140 of 2000. This is directly contradictory what they state in the writ petition. This is recorded at page 129, my lord.
Where do they say? The application is also there. Where
In
do
the
they say
application
so?
also they say that.
Yes, where do they
Yes,
say?
Please. My lord, that page 29, annexure, page 29,
Of the
paragraph H,
of the application.
application.
The first volume.
First volume,
Yes.
paragraph H, my lord.
Mm.
The applicants submit that on 3/12/2018, they were called by the Davangere Azad police station for recording their statements in crime number so and so. At that stage, they came to know that on the statement made by Tipesh Nayak, who is accused number 1 in crime number 140 of 2017, that the applicants also involved in examination malpractice, which they were accused. After recording the statement of the applicants, were directed to appear for investigation. I'm sorry, my lord, it's the next paragraph. Paragraph I, my lord. The my lord, instead of reading the whole paragraph, it's a lengthy paragraph, my lord. I state that, my lord, everything stated in this paragraph is incorrect, my lord. The applicants approach the first respondent stating.
Where do they say that?
Yes, my lord, at the bottom of the
It is
page,
accused in crime number 140.
at the bottom, my lord, it is stated, a perusal of clarification issued by the fourth respondent reveals that the applicants are not arraigned as accused in crime number 140 and 172 of 2011. Whereas in the writ petition, which is filed around the same time, they have challenged the very same crime number as they saying that they are arraigned as the.
This exactly verbatim was their case in the writ petition also. This court has accepted it.
No, here they are saying they're not arraigned as arrested.
This is verbatim
No, my lord.
their contention before the court also. Please see the judgment that you have just now read. This specifically was their case.
Lord, here they are saying
Like
they're
you
not
said,
arrayed as.
how could they have been arrayed in the manner they say it was done?
No, here they are saying based on the letter of the fourth respondent, that is the superintendent of police, they are not arrayed as.
So that exactly was their contention before this court also. Please read the judgment.
But it says, therefore, based on this information, petitioners were arrayed.
What information?
Lord, information given
Court
by.
2/2020.
I'm sorry.
Court 2/2020 communication. That specifically was their case. Please see their prayer in the writ petition before this court. The writ petition.
I'm sorry, my lord. This is based on the, my lord, information given by the accused persons, my lord.
Exactly, that specifically was their case before this court also. It was argued, it was read out on the last date. Their case in both the, as a matter of fact, that they have filed the application, they have not stated in the writ petition. That you are right. But the
Lord, here they are clearly saying.
verbatim the same. This exactly was a contention before this court in the writ petition also. Please verify.
Lord, here it is clearly recorded that they were arrayed as respondents in the writ petition.
Yes.
In the application, they are saying that
Yes,
they're
we
not
understand.
arrayed as respondents
Yes.
in the. Lord,
Yes. Yes.
my lord, my two main submissions, contentions are this, my lord. My lord, it's a settled position of law that an acquittal is not conclusive of the suitability of a candidate as held by the
What
Honorable
else do you
Supreme
have
Court
against
in.
What else do you have against them?
I'm sorry.
What else do you have against them? It is not an acquittal.
No, I'm coming to that. I'm only stating that,
Yes.
stating that as a prelude to what I'm. Lord, in Authorized, it has been held that an acquittal is not conclusive of the suitability of a candidate. The employer can go into the question of whether the acquittal was on the basis of merit or whether it was only on the basis of a technicality and not an honorable acquittal. That is.
Was the question of acquittal here?
No,
when
I'm
they are
only
not-
stating that as a prelude, ma'am. Therefore, in the same manner, my lord, even in the case of submission of B report, also, it is still open to the government to assess the, my lord, I have a judgment to that effect. My lord, the reason why I say that is.
Counsel, please.
The
The direction of the tribunal is to consider their request because they are included in the final list.
Please.
It is not something to be lightly brushed away. There is an inclusion in a final list. You have been directed to consider on what material you can deny them appointment.
my lord,
That is all that has been
But
directed.
if it is not limited to the, just looking at the final seniority, final selection list, my lord,
No,
we have no
no
difficulty.
appointing authority can be given some kind of a free hand to do whatever it wants. Especially not not an appointing authority, which is a public authority as well. It has to be circumscribed.
My lord, may I
It
just,
has to be circumscribed by rules, by the necessity to act in accordance with law fairly. And as
I'm
a
only on
stat-
that point,
you
my lord.
cannot act in specific manners as you like in different cases. Absolutely no such power is given to any public authority or any appointing authority. Here is a case where, as a matter of fact, the FIR stands squashed. Separate FIRs were registered. Those FIRs were investigated into and B reports have been filed. You cannot come up with anything further out of, you can, as a matter of fact, assess whether there is any suppression of material fact with regard to their inclusion in the list. Nothing else. That is all you can go into. All this cannot be ground for you to now say. So things which are extraneous to the selection cannot be grounds for you to say that they are to be non-suited or kept out of employment for other reasons.
My lord,
Cannot.
that is my submission, my lord.
That
The
cannot-
submission is that if
Is it your
PR
contention that
acquittal is not conclusive of the suitability of the candidate,
there
in the
is
same way,
not an acquittal at all?
B report is
Yes.
not conclusive of the suitability. That is my respectful submission.
Yes, we'll consider.
May I just pass on this one judgment, my lord, which I'm relying on.
Please pass on your whatever your dates and events that you seek to rely on as well. Please make it available. Yes. with a copy to the
I just pass.
respondent as well. Yes.
I may be permitted to just state two things, Your Lordship. One thing is that with regard to limitation, my learned friend has specified that there is a delay in the impugned order which is under challenge was passed in 2022. And the writ petition herein is filed in 2023, almost more than a year of delay. So that my learned friend has not explained regard to that. One more aspect is that with regard to suppression and misrepresentation, not even a whisper in the writ petition. This entire writ petition, Your Lordship can gauge the entire writ petition with just one paragraph, paragraph 13 in this writ petition. Their entire grievance was that an investigation is pending, hence his character is under cloud. So when the investigation is pending, the KSAT could not have asked him to consider. When that itself has concluded, there is no question of anything being raised against. And also there is a major difference between acquittal and a B report. This is wherein to say the government itself is blaming another organ of the government, which is the police investigation. Either they should have challenged the B report itself. This B report has not been challenged, it has been accepted. One more aspect, the entire case involves around a final selection list. When the government accepts the final selection list and has given the appointments, they cannot now go back and say that these candidates who have been in the final selection list, now that the cloud has passed, they cannot say that they cannot consider that their final selection list. One more aspect is that as on the date of the impugned order, the question is, were there any FIR pending? The 142 was not there. Yes. 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 Several times on these facts. Yes. Speak away to what you want to say.
Just the list of dates, no? I'll.
What to be considered. Yes, I'm very grateful.
Can I submit it on Monday, my lord? List of dates. Yes, because the lengthy. I will.
Your Lordship. Yes, yes, I shall. I shall do so. Yes, yes.
Number 22, Rutvish MK.
This is on Monday. So
Please.
yes, yes.
22. I appear. Let's matter pertains to departmental inquiry. Yes, ma'am. Your Lordship's my lords had in fact heard this matter, my lord. Your Lordship's recollect. Let's the petitioner, my lord, before your Lordship's my lords.
Acquitted in the criminal case.
Acquitted in the criminal case. And my lords, the PW1, my lords, has turned hostile in both the criminal trial as well as in the inquiry.
Hear this on merits.
It
will require a hearing on merits.
In fact, your Lordships had heard, your Lordship may recollect. The incident is now, my lord, about 23 years old. If your Lordship
was the crime registered?
Well, it's 2002.
Crime was registered.
Crime was registered, my lord. I'm acquitted, departmental inquiry is initiated. In 2022, after 2 decades, my lord, penalty is imposed. 23, I go to the tribunal.
Therefore, the question as to what was proved in the inquiry will now have to be considered. And whether it was the
tribunal has now remanded it back to the inquiry officer.
After finding that the inquiry does not answer the issue.
No, my lord, tribunal did not get into any of that issue. Tribunal only went on the issue of recommendation is not supplied. Therefore, we'll remand it back. No, my lord, I'm today, as on today, my lord, it's 22 years old, my lord. The incident itself.
More the reason why it should be heard on its merit.
Yeah, very well. In fact, your lord.
When immediately after.
Any date convenient.
Keep a date. November first week.
Please.
This cannot be easily done. That is the difficulty.
That's it. I have filed the amended cost title. May I just permit me to hand over the amended cost title because I had impleted the broker.
Great.
23, government advocate.
For the respondent.
We called after vacation, my lord. In this matter,
He admitted medical reimbursement.
my lord, in this, my lord, he inter-cadre transfer, my lord.
Just a
Serial number
moment. I'm
23.
sorry. Yes, yes,
There is an interim order until further orders in this matter. I got confused with the previous matter, my lord.
yes.
I'm sorry, my lord.
Contract.
But I have
backlog,
filed
On a
vacating
contract
case.
basis, he was
change of
appointed.
cadre, qualification. Yes, we'll have it
And
after vacation.
The
You're
absor-
appearing. You're appearing in this matter.
Yes, my lord, for respondent.
absorption rules are under challenge before the apex court. On that ground, the interim order has been obliged.
Just after holidays.
Is it after vacation?
Yes.
Please, please.
See number 24, Karumbaya TA.
Hearing for.
121 days delay. Deposit of half of the decree amount.
We've deposited half of the amount.
For eviction, my lord. My lord, execution proceedings was filed before the trial court. They had appeared before the trial court. They said, my lord, kindly, my lord, if I may, how to say? They have to vacate the premises within 1 week. Twice they took that time. Within 1 week. Thereafter, they have appeared. Before,
1 week?
Please, my lord. Thereafter, they have filed this. Kindly take, my lord, page number 3, my lord. Order dated 15/7/2024. There was a
Where
report.
does it state?
25/6/2024 is where, my lord, the talks of settlement was taken. On 15/7/2024, my lord. Advocate for JDR prays weeks time to vacate the premises. Other side has also consented for the same. Hence, time granted for reporting settlement. Kindly take next 22/7. Another advocate for JDR once again prays for weeks time, opposed by the other side. 4 days time granted to do the needful, that is vacating the premises. Thereafter, they approached this honorable court stating that I wanted to vacate the premises, but now I want to file an appeal and.
My lord, I don't think this 4 days time granted to do the needful is with respect to vacating the premises.
You are M. Bhaskar Rao
I will seek.
and Suma B. Rao.
Yes, my lord. I will seek necessary instructions, my lord.
They,
As per my instructions, we will vacate the premises within 6 months.
my lord,
If
The-
this is correct,
I was not aware.
the order date, my lord, is on 11/1/2024. Decree. Decree date is on 11/1/2024. Even 6 months from then, my lord, now it has lapsed. In fact, we want that premises for our business also. I am running business in a tenanted premises. Right, they took time before the executing court, my lord. Thereafter, on 2/8/2024, they moved before this.
if as a matter of fact, it is after undertaking before the executing court to vacate within a week.
My lord,
That
kindly
without,
Certified copies.
pass over the matter, my lord. Senior will appear.
Right, they took time, my lord, there.
My lord, we've been
On
in these
26/7/2024
premises for like
also. On
20,
12/8/2024,
22
they say
years,
that.
my lord.
it is not the issue. That is on the merits of the matter.
Even the grounds of appeal also, my lord, they do not say anything about the appeal. What they say on the judgment, my lord, they say that I wanted time, court did not grant time, hence I am coming before this honorable court for. That was.
Pass over my-
Within what time will you vacate?
As per my instructions. 6
Passed over
months.
to tell us within what time you will vacate.
Sagar BP.
My lords, I pray for a pass over. So the arguing counsel has been. held
This
up
is
in
the matter. 25. Medical reimbursement.
Pardon?
Medical reimbursement.
My lords, the arguing counsel has been held up in another court. I kindly.
Just after vacation. Yes. Yes.
Passed over matters. See number 1. Parinal.
In this case. My lords, the The present appeal, my lords, is arising out of the order, my lords, of 24/7 denying the relief of ad interim ex parte order, my lords. Before I dwell into the main merits of why the order I have challenged, my lords, kindly, if I may kindly invite the reference of this honorable court to page 24 of my appeal to show what is the nature of the infringement.
The nature of the infringement is not the issue before us now, whether this denial of the ad interim order by itself,
Please, my lords.
without
Please, my lords.
the issue being raised there.
Please, my lords. I'll just come to that, my lords. I'll explain why, my lords. What has happened is that insofar as the impugned order is concerned, and if I may kindly invite.
Or there,
Pardon, my
they
lords?
have to here or there. Now they have to be put on notice.
I'll come to that, my lords. I'll explain why it can't be done, why I'm requesting that the notice not be issued immediately for this reason, my lords. My applications before the court is not just for injunction, it is also for a court commissioner to be appointed for seizing the infringing products. The reason why I made that application, my lords, is that under the guise of the infringing product, my fear is that spurious products are being sold to the market. Now, my lords, in a case of trademark infringement where I'm asking for a court commissioner to be appointed to go and search and seize the premises and also retrieve the infringing labels and the products, the moment notice is issued, the nature of the infringer is that the offending products are destroyed and they disappear overnight. For that reason, my lords, the issuance of notice would essentially mean that the entire evidence that I need to show the spurious nature of the product will probably be destroyed and I may not have access to it. The reason why I've been as hesitant in terms of taking out notice is only for that reason. Had it been a case where I was not apprehensive of the quality of the product being sold and the nature of the injury to the public, I would have probably only gone with an injunction simpliciter. This is the mischief, my lords, that I'm trying to address through my second application for the appointment of a court commissioner. If notice goes, my lords, then I may not even be able to trace that gentleman anymore. He may simply disappear. That, my lords, is the reason why it's my humble request that if the notice is issued, it's as good as my suit becoming infructuous because I may not be able to trace him afterwards.
What, according to you, from when are they in the market?
My lords, that insofar as the market is concerned, kindly come to my lords an invoice that I have filed, which I got to know only recently. So I kindly invite my lords reference to page number 146. This was as recently as about 2-3 months back when a trader in Bangalore, my lord, ended up selling this product. Because of which I got information, my lords, because what happens, my lords, is when somebody goes to the shop to buy coconut oil kind of a product, he will simply ask for Nirmal coconut oil. He will not specify whether it is KLF Nirmal or Kirti Nirmal. So the shopkeeper may very well give him the defendant's product, though what the consumer thinks he's buying is the plaintiff's product. Insofar as the claim of usage my lords is concerned, they have filed an application for the registration of the trademark that they have filed.
When?
I'll come to that, my lords. It's 25/2/2021, which is found at ink page number 117 of my appeal. And there, my lords, in 118, they say proposed to be used. There is no date mentioned as to when they have used or when they are using it. And my lords, within the context of trademark infringement, my lords, each date of sale of the infringing product qualifies as a distinct cause of action. As soon as I've gotten to know that there is an infringing product in the market, I've taken steps. But I've already taken steps to oppose the trademark application. Whatever this application they filed for registration of the mark, I have promptly filed my notice of opposition to that. And I believe the registration application has been refused recently during the pendency of the suit. And my lords, I am a prior user, even as of the date of this application in 2020, when they say proposed to be used, I have been using my trademark since 1992. And my entire trademark comprises of KLF Nirmal. KLF is registered, Nirmal is registered, KLF Nirmal is registered separately. Each distinctive element of my trademark is registered. My turnover is in the vicinity of several hundreds of crores. My lords, I have invested considerably in advertising and marketing. And I've produced a chartered accountant certificate, the invoices, the awards, the press coverage that my brand has received. This gentleman sees that there is some reputation that my mark has. He goes ahead and dishonestly adopts the mark. And it may be seen, my lords, that he highlights Nirmal and reduces the imprint of Kirti on it. It is almost as if he wants people to see Nirmal more than he wants them to see Kirti. It's a very deliberate design on their part to ensure that consumers are confused and they buy their product while in fact the query may be for my product. Each of the registration certificate for the distinctive elements of the mark, my lords, are produced as per Annexure B3 and B8 to B3 to B8. Which is found at page 80 onwards, my lords. Earliest registration of mine goes back to the year 1994, which is found at 75.
Yes, my brother judge appears to think that this appeal itself would not be maintainable. You have to go before
I'll
the
come to that,
court.
my lords, because if I may just invite the reference of this honorable court to the impugned order, and I'll explain why I have preferred an appeal, my lords, because it's a very pertinent question, whether or not it qualifies as an appealable order. Kindly come to ink page number 37, my lords, because it is not a case where notice simpliciter is issued. Detailed reasons have been provided. Kindly come to ink page 37, my lords, and I'll read out the relevant portion. I've gone through the principles laid down in the above referred cases that on going through the contents of the annexed affidavits and prayers sought in the application, so also perusal of the documents at this stage, it appears that the plaintiff has not made out valid grounds for considering the prayers sought in the application's ex parte. I parked this for 1 second for my lord's consideration. There's a specific finding saying that no grounds have been made out for granting.
Just a moment. It's not only. Yes.
Section 12A of the Commercial Courts Act has been cited to say that I should have gone before pre-institute, practically making out grounds for rejection of the plaint. Therefore, my lords, I'm relying upon the judgment of this honorable court. In the case of Kela Group Enterprises versus Madhu. No doubt, my lords, this was rendered in the context of section 37. But in paragraph 19, my lords has made a distinction between an order of ex parte injunction where reasons have been provided for non-granting of an ex parte order versus an order where no such reasoning is provided.
Paragraph?
19, my lords. I'll read out, my lords. There is one more angle to it. Though the order refusing ex parte interim measure is a discretionary order, the discretion conferred on the court is not absolute, but is guided by certain principles. While deciding the ex parte interim measure and ordering notice to the respondent, the court must arrive at a prima facie conclusion that the object of issuing ex parte interim measure would not be defeated by delay caused in issuing notice to the opponent before considering the prayer for interim measure. Thus, if the court takes a view that there are no grounds to pass the ex parte interim order, said view and consequent order declining ex parte interim measure is in the nature of the final order, as the relief of ex parte order prayed for by the applicant is declined once and for all in the said proceeding. The reason is quite simple. If an ex parte order is declined, then after notice and hearing the other side, if the interim measure is granted, such an order is not an ex parte order. In that view, the order refusing ex parte interim measure has all the attributes of a final order, as a prayer to grant ex parte order is declined and rendered irreversible by the court by issuing notice to the opponent. I pause here for a second, my lords. This is exactly what has happened in our case. There is a determination made by the court saying that there are no grounds made out for granting of the ad interim ex parte relief. That being the case, it assumes the character of a final order, which is appealable under Order 43, Rule 1R. Therefore, my lords, my respectful submission is this also stands on the same footing as what is contemplated by paragraph 19 of this judgment, to say that once there is a determination made, the appeal is maintainable. And because a determination has been made not just on the basis of the delay itself, but on the basis of 12A, my lords, which is patently erroneous, and I will demonstrate with reference to a judgment of the Supreme Court, I have pleaded in my plaint that there is urgent ad interim relief contemplated by the suit. Therefore, 12A need not be complied with. In spite of that, a finding is given that I had prior knowledge and I should have gone under 12A, giving grounds practically for rejection of the plaint. Therefore, my lords, this stands slightly apart from a typical case of an ad interim ex parte order where no reasoning is provided. Therefore, appeal is maintainable is my respectful submission before this honorable court.
Yes.
May I proceed to the merits of the case, my lords?
Your contention with regard to 12A?
Please, my lords. I'm relying upon a division bench judgment of the Honorable Delhi High Court. May I please invite the reference of this honorable court, my lords, to paragraph 30 of this judgment, which is found at internal page number 9. So in this case, a contention was taken that an application under Section 12A ought to have been made seeking waiver of the requirement of pre-institution mediation. The court's reasoning on this is found at paragraph number 30. The contention that it would be necessary for the plaintiff to file an application seeking exemptions from the provisions of Section 12A of the Commercial Courts Act 2015 is unmerited. The court cannot accept the said contention for several reasons. First of all, there is no provision under Section 12A of the Commercial Courts Act 2015 that requires the plaintiff to make any such application in a suit which involves urgent interim reliefs. As stated above, if the suit involves urgent interim relief, Section 12A of the Commercial Courts Act 2015 is inapplicable, and it is not necessary for the plaintiff to enter into a pre-institution mediation. 33 may kindly be seen, my lords. Next paragraph. The court also finds it difficult to accept that a commercial court is required to determine whether the urgent interim relief ought to have been claimed in a suit for determining whether the same is hit by the bar under Section 12A1 of the Commercial Courts Act of 2015. The question whether a plaintiff desires any urgent reliefs is to be decided solely by the plaintiff while instituting a suit. The court may or may not accede to such a request for an urgent interim relief, but that is not relevant to determine whether the plaintiff was required to exhaust the remedy of pre-institution mediation. The question whether a suit involves any urgent interim relief is not contingent on whether the court accedes to the plaintiff's request for interim relief. I pause here for a second, my lords. In my plaint, if I kindly invite my lord's reference to the plaint filed before this honorable court, before the learned commercial court, And specifically, my lords, paragraphs number ink page number 55 may kindly be seen, my lords. My apologies, ink page 56, para 35.
Yes.
The plaintiff submits as there's grave urgency in the above case, and hence the suit is being filed seeking liberty to produce additional documents. Further, the present suit contemplates urgent reliefs. On that basis, my lords, the judgment of the Honorable Delhi High Court holds that once I have pleaded that there is urgency and urgent reliefs are being contemplated, I filed IAs seeking ad interim ex-parte reliefs on the grounds of urgency. My determination, my lords, ought to have been taken into consideration before a finding is given that I ought to have taken the recourse under Section 12A. And my lords may kindly appreciate one submission, my lords, that if I give that notice of mediation, he may very well disappear and walk away with the infringing products. I may never be able to find him. The nature of the social evil that I'm trying to address is of a kind where these defendants are fly-by-night operators. They may not be around in the same place beyond the period of a couple of months or a couple of years. And the moment they have notice of these court proceedings, they may not even want to come forward. For that reason, my lords, in a case of this nature especially, courts have passed orders against unknown defendants. There have been orders called dynamic plus injunctions where websites which are not even in existence have been asked to be taken down. That is because, my lords, these kind of cases stand on a different footing. And my lords may kindly appreciate that I am here before this court not only on behalf of myself. A consumer who may end up consuming a spurious product is as much the beneficiary of an order of this honorable court granting ad interim relief as is the plaintiff in this case. That is the reason why, my lords, when pharmaceutical products or food products are involved, because there's a grave implication on the health of the consumer, the test employed is a consumer of average intelligence and imperfect sense of recollection. All of that only goes to show one point, my lords, that there is a public policy initiative in terms of being able to grant an order of this nature. That becomes completely defeated if the notice is issued, because tomorrow he may simply go to another place, assume a different name, and continue the same infringing activity. That is the reason why, my lords, most of these cases, the critical juncture of the suit is the interim relief. The interim relief is granted, my lords, that itself provides sizable relief to both the plaintiff as well as the relevant class of consumers in the market.
What do you say in the plaint about the defendant and his activity?
Please, my lords, if I may kindly invite the reference of this honorable court to paragraph number 50, my apologies, my lords, ink page number 49.
Yes.
Paragraph number 19, my lords. The plaintiff submits that as part of its efforts to protect its trademarks, it was reviewing the applications filed for registration of identical or similar mark. During this exercise, the plaintiff discovered that the first defendant had filed an application number 487 so-and-so in class 29 for registering of the mark Kirti Nirmal for edible oil, which is more fully described in Schedule B1. As per the first defendant's application dated 25/2/2021, the infringing mark was proposed to be used on the date of filing the said application. A copy of the application filed is produced herewith as per Annexure H1. Plaintiff promptly opposed the said application and the same is pending as of date. This has been subsequently allowed, my lords, and the application has been rejected. Copy of the said opposition filed is produced herewith as per so-and-so. In the meanwhile, the first defendant filed another application for the registration of a device mark containing the words Kirti Nirmal Vide application number so-and-so in class 30 for various food products. The said trademark is more fully described in Schedule B2. The said application was refused. Copy of the said application is produced herewith as per Annexure J. The plaintiff further submits that the second defendant, which is none other than a company that appears to be incorporated and promoted by the first defendant herein, has applied for the registration of the trademark Kirti Nirmal in the form of a device in class 29 for inter-alia, oil and fat. The said application is numbered so-and-so. The said trademark is more fully described in Schedule B3. As per the application filed on 22/4/2022, the trademark is shown as proposed to be used. However, to the plaintiff's utter shock and surprise, the plaintiff has recently learned that the defendants number 1 and 2, who are clearly aware of the plaintiff's exclusive rights in respect of the mark Nirmal, have already received the notice of the plaintiff's opposition filed in respect of the first infringing mark, had already began manufacturing and selling coconut oil and other products such as rice, jaggery, and salt under the name and style of Kirti Nirmal. A copy of the extract of the website of the first and second defendant advertising and displaying the product bearing the infringing mark is produced herewith as per Annexure K. The plaintiff also learned that the first and second defendant's products were sold by various traders across the country. One such trader is his third defendant who has sold the infringing products in the city of Bangalore, as can be seen from the invoice issued by him, which is what I pointed before this honorable court. Next paragraph, my lords. The plaintiff has further learned that the fourth defendant has been marketing the said products such as rice, jaggery, salt, and edible oil, and the fifth defendant is involved in manufacturing and packaging the first and second defendant's products. The fourth defendant has been incorporated only in the year 2020. Plaintiff submits that it is currently unaware of the details pertaining to the nature of the fifth defendant's entity and the details of the person running the fifth defendant. Plaintiff reserves liberty to furnish such details and craves leave to make suitable amendments to the plaint as and when the plaintiff becomes aware of the same. Copy of the label disclosing defendant number 2 as the manufacturer and defendant number 4 as the distributor and exporter of the products is produced herewith as per Annexure M. Para 25, my lords, infringement and passing off. The plaintiff submits that the adoption and use of the first and second infringing products, that too for coconut oil, jaggery, salt, and rice products, is illegal and unlawful. Not only are the defendant's infringing products deceptively similar to the plaintiff's products, but the products of the defendants are also similar to those of the plaintiff. As can be seen from the applications of the registration of the said marks filed by the first and second defendant themselves, the said marks are not in use even as of the year 2022. However, the plaintiff's trademark comprising of the word Nirmal is in use since the year 1992 and is already registered. The first and second defendant had notice of the plaintiff's exclusive rights in respect of its trademarks by virtue of the plaintiff's extensive success, goodwill, and popularity. Thus, it appears that the first and second defendant have dishonestly and fraudulently adopted the first and second infringing mark with the sole purpose of exploiting the plaintiff's hard-earned popularity and goodwill to unjustly enrich themselves. The plaintiff submits that the first and second infringing marks are deceptively similar to the plaintiff's registered trademarks, more fully described in Schedule A. This has already caused confusion and is likely to cause confusion as regards the source of the products bearing the infringing marks. Furthermore, the consumers in the market are likely to be deceived into thinking that the products of the defendants number 1 and 2 are the products of the plaintiff. It also threatens to dilute the distinctive character of the plaintiff's trademarks.
Yes.
This is the sum and substance of my case, my lords. And as can be seen, they have emerged only recently in the year 2020. 2022, they say proposed to be used. I got to know of a sale in 2024. I've approached the court at the first possible instance. I'd even produced judgments before the Honorable Commercial Court to show that every date of sale qualifies as a distinct cause of action, and therefore delay in an IP infringement case is no delay for the ground purposes of injunction. All of this, my lord, has been neglected on the one singular ground that these cases don't apply to the facts of the case. No detailed reasons have been provided on that front. 12A has been cited, which is clearly not applicable. Therefore, my lord, grave injustice will be caused if the ad interim prayer is not granted, because if they leave the premises, then I'll never be able to find them again, my lords. Therefore, I'm praying for the stay of the order, as well as for the ad interim reliefs of injunction and appointment of court commissioner.
Yes, reserved for orders Monday.
My lords, my only difficulty is the matters posted on Monday, my lords. If the stay application can be considered, and until Monday, if a stay can be granted on just the order, I'll be most grateful, my lords. That is my only request. IA number 4. IA number 1, 2, and 3, I fully appreciate, my lords. IA number 4.
Orders will be passed on Monday at 10:30.
Please, my lords. May I also place the list of authorities, my lords?
Please.
Greatly obliged, my lords.
Yes.
Greatly obliged, my lords.
B group, number 26, government advocate.
AICD scales of pay.
Yes, ma'am.
We have
But,
filed our.
if I may sum up, my lord, very briefly, but the two respondents, lord, on the same cause of action, they filed two cases. the first case culminates in a contempt proceeding being dropped on the ground that the direction given, the relief granted was only merely a direction to consider, and that direction has been satisfied by the government considering and rejecting the claims. Now the question is whether in the second case there should be a different outcome, or is it not barred by res judicata? That is the question.
What is the direction here?
But, the writ petition challenges both the order passed in the contempt proceedings as well as in the application. The prayer in the application is to grant the relief which was granted in the by the High Court. In the first round of litigation, they are not successful. They want to move from grade 3 of AGP to grade 4 of AGP, which is from assistant professor to associate professor. That was actually granted, my lord, by mistake, and it was rescinded. They challenged it before the tribunal. They were unsuccessful. The High Court accepted the challenge, and which was allowed the prayer, my lord. The state challenges the order of the High Court before the Supreme Court unsuccessfully, and thereafter contempt proceedings are initiated. And in the contempt proceedings are dropped on the ground that the relief granted was merely a direction to consider.
Not by us. Contempt was not initiated by us.
They were parties to the writ petition.
No.
They chose. Well, I'll point out. Kindly see.
We are not parties to the contempt.
Indeed. Not parties to the contempt, but they were parties to the writ petition. Where they got the relief. And they again file an application. Please grant us the relief granted in the writ petition. Kindly see the, my lord, at page 234. At
Just
serial
a
number.
moment, just a moment, please. Page 37 is the direction. As could be seen from the order of the High Court, it has been held that the petitioners are eligible for the post of associate professor from a particular date. Since the authorities have not taken any action even after the disposal of the SLP on 28/1/2020 and after applicants submitting their representations, they are before this tribunal seeking direction to consider their request as per the direction issued by the Honorable High Court and to take a decision within a time frame. In view of the above, we are of the view that the applicants have made out a case to direct the respondents to consider their representations dated 26/4/2021 at A16 and A17 in accordance with law in the light of the decision of the Honorable High Court in that regard and to take a decision. Yes.
The decision of the High Court was already in their favor.
Which was the decision of the High
My
Court?
lord, in
Then
volume
what
2,
happened
my lord,
was, to complete the narration
216.
pursuant to that direction.
Let
Very
him
well.
complete the narration. Yes.
My lord, page 216, volume 2.
Hmm.
My lord, may I just take your lordships to page 230,
Hmm.
where at serial number 3 is one of the respondents herein. He was party to the writ petition. He has got the relief, which he again claims before the tribunal.
Okay.
230, my lord. Shailesh Chandra, my lord.
Hmm.
Shailesh Chandra Gudihatti. My lord, he is one of the respondents. The other respondent is at page 230. My lord, 234 at serial number 1, Pradeep Kumar.
What is the direction of the High Court?
But the direction of the High Court, 279.
Petitions are partly allowed. Orders are quashed. Consequently, order dated 8/12, directing Director Department to recover amount of salary drawn by the petitioners in the post capacity of associate professor is quashed. In view of the stand taken by the government that the petitioners are eligible for the post of associate professors from September to so-and-so order earlier has become infructuous, there is no need to pass any order. It is open to such of the petitioners to approach authorities for their remedy to recover the amounts. Therefore, you had already recovered. The recovery had already been effected. It was to refund those amounts.
Only those that.
That was the direction.
Please.
You took it up before the Apex Court. The Apex Court dismissed this,
Please.
that the order of the High Court has to be given effect to.
Yes, my lord, the contempt proceedings ended, my lord, in the court holding that the direction to consider was considered and rejected, and it is in Therefore,
Whether that is correct or not is what is being considered now. Can you say after the apex court has rejected your SLP that we need not comply with the directives of the High Court?
No, recovery part, we are not challenging it.
You have to prepay it.
Non-millards, we are not on
Recovery is
the,
not-
millards, we are not on the
recovery is
recovery
not
or
in dispute.
repaying. Redesignation, which your lordship saw that
Redesignation is the only
second part
concern.
of the
Recovery
order,
is not in
millards.
dispute.
In view of the stand taken by the government, your lordship gets at page 279.
The petitioners are eligible for the post of
Post of associate professors,
from September to November 2013.
13. That doesn't,
Passed by, they had already been redesignated.
Please.
Therefore, the order passed by the government on 29/1/2014, rescinding its earlier order, has become infructuous. Therefore, the redesignation is in order, it has to be granted.
I just pass on the
Hmm.
order which was passed in the contempt.
Contempt by whom? By the tribunal.
Before this.
millards, some of the petitioners, not these respondents, had filed contempt saying that after the dismissal of SLP, the orders were not being complied with. That, millards, the contempt came to be dismissed, saying that it is, please, anyway, let him complete. I am on.
Mostly consideration, that was ordered.
Indeed.
Hmm.
But they were
That was-
parties to the writ petition.
But
they
please
got
see the
relief in
last,
writ petition.
last para in that. I am not a party in that contempt.
He was a party to the writ petition where he got the relief.
Writ petition, I might be a party. Milord, my learned friend goes on saying that I,
And he seeks the same relief in the, before the tribunal.
naturally. Please see the last portion.
Yes, because it is not a contempt, that does not mean
Look.
it is not wrong.
But he,
Complainants are at liberty to work out the,
Contemptuous and being wrong.
but if he has already got the relief before the High Court,
It is
he
not
seeks
that
again the same relief in the tribunal.
You did not give him the relief, which is why he's went before the tribunal. Some of them chose to approach in contempt. This court said
you work out your remedies.
a grievance elsewhere in accordance with law. Therefore, even those petitioners who, persons who are parties to this, this order,
Please,
move the tribunal, absolutely nothing wrong.
Lord, they've already got the relief before this
They
honorable.
have already got the relief, why would they go before? Because you're not granting the relief that they claim that. they
Therefore, the
claim
remedy
in
was contempt
Uh,
proceedings they've initiated, therefore.
It's rejected with permission to go before appropriate authority. They've gone before the tribunal. Even the petitioners herein could have gone before the tribunal. Nothing stands in the way. This court in a contempt petition cannot decide on the correctness of the order.
Indeed, ma'am.
All that can be done is whether there is prima facie contempt in the face of. The court finds that it is not contemptuous.
So the first case came to an end. It culminated in the contempt being dropped, my lord.
It would not. Only the contempt is dropped.
Contempt is dropped, millards.
Dropping
it
of
is-
the contempt cannot extend to saying that they cannot challenge it anywhere.
In a
Whether a
contempt
particular-
jurisdiction.
Whether a particular stand amounts to an undertaking depends upon host of factors. A piecemeal approach would not help. Even if it is assumed that the stand of government in subject of writ petitions amounted to an undertaking, same is qualified that the candidate should possess PhD. If that qualification was satisfied, arguably complainants would have had a case of contempt.
In this case, we have, those cases, they did not have PhD.
So those persons who have PhD have, even going by this judgment, this order in contempt, they have a right to even move for contempt.
No, they don't have PhD, ma'am. That is the.
My lords,
They did
I
not
don't
have-
know, my learned, please see my synopsis.
No, no,
We have
not-
a, my
not they-
learned friend has to see the synopsis. We have got.
Did they acquire the PhD is the question, not subsequently. If they have,
Then
they can't.
Please qualify it.
They can't ask for redesignation based on an earlier date when they did not have PhD qualification.
See, therefore, the question is not that even those persons who did not have PhD could have challenged it before appropriate forum.
Please.
Now, here are persons who chose to go before the forum.
Lord,
Prevents.
a relief is granted by this honorable court, and they again go approach the tribunal and ask, grant the relief granted to us in the High Court.
You still do not grant the relief.
They have rejected.
Said and done, you do not grant the relief. You reject it. They have every right to challenge the rejection. It may be open to you to say that this is something which
Lord, a
is.
new representation is given for the same relief. Creating a new representation cannot create a new cause of action. It's the same relief they are seeking. They were parties to the first application before the tribunal. And that relief was initially denied by the tribunal and was granted by this honorable court.
Is it your contention that you are actually in contempt and you should be hauled up for contempt and not in the tribunal for a wrong order? We don't have any problem. We'll say that you're admitting that.
KAT has initiated contempt, my lords.
We can, as a matter of fact, take action for contempt if it is in the face of the court.
But in fact, the KAT has initiated.
Lord, my contention is that already for the same relief, my lord, same persons for the same relief.
They approached you on the basis of the judgment of the High Court. You rejected it. They went before the tribunal. That in the meanwhile, somebody else approached the High Court and
My lord,
got.
the question is, can they give representation for the same relief once again? Which they have already got before the tribunal,
If you
before
did
the
not-
High Court.
If you did not grant the relief as directed by the High Court, they could have. Otherwise,
But it could be
dangerous.
clearly barred by res judicata, my lord, because the same relief can't be.
Their stand is barred by, I am saying their stand is barred by res judicata. First time I am hearing I am barred by res judicata.
Lord, kindly see the prayer in the application. Grant the relief which was granted by the High Court.
And did you grant them the relief that was granted by the High Court?
My lord, the High Court holds in the contempt proceedings that the relief granted was merely a direction to consider. And the direction has been fulfilled. Kindly see, my lord. The direction has been complied.
Therefore, that order is amenable to challenge. That is what the High Court says. Contempt are dropped, notice discharge, complainants are at liberty to work out their grievance elsewhere in accordance with law, and in that connection, all contentions of the parties are left open. Nothing against these persons challenging the order before the tribunal. How can it be that persons who are not parties cannot challenge it?
Lord, it would mean that now there will be two different outcomes for the same relief. my lord.
If it is your contention that you are in contempt and not
Lord,
able to answer, then we can consider the contempt application again on your admission.
my lord, my respectful submission is we have successfully, this contempt has been dropped, my lord. We have been successful in
Only
the contempt.
contempt has been dropped. Please, don't let us take things to absurd limits. Contempt being dropped will not foreclose the other rights. Yes.
Lords, we have filed our synopsis, giving out the facts.
Hmm.
That's if your lordship just takes, it's a matter of the redesignation. And so far as, lords, we have set out, the only issue was the government, my lords, by redesignating the post, while appointing us, my lords, we were appointed as assistant professors. By that time, they are redesignated the post. They gave us the benefits also, but the government order said, you should, we will be entitled to it after 3 years to the post of assistant associate professor.
Associate.
Having given us, my lords, they sought to recover the money by rescinding the earlier order notifications of redesignation. Since AICT is the one which redesignated all over the country. Then, my lords, the matters came to the High Court. Before the High Court, it was all adjudicated. All these issues were adjudicated. The only issue was 3 years I am entitled for redesignation. I was to obtain a PhD within 7 years. Now AICT has issued a notification saying in case you do not obtain a PhD within 7 years, you will not be reverted back. But there is a DA and TA, my lord, certain grades of pay. You will not be entitled to that pay which we have set out.
Grade pay will not be.
That's all.
Your grade pay.
Yes, my lord. AGP, what is called as average grade. Now, my lords, since the matter ended, we go before the KAT saying that the state government did not take any action to redesignate him. Today also, I am only designated as assistant professor without pay of the associate professor.
So,
Yes.
strange submissions.
Well,
Yes.
lords, the KAT only gave a direction to them. If your lordship sees in the appeal memo, my lords, the first volume, the impugned order of KAT is dated 13th July 2022. My lords, they did not comply with that. Then, my lords, what they did was they rejected my representation. If your lordships have my synopsis, I have set out, my lords, the list of dates. They issue an endorsement on 10/1/2023 rejecting my representation for redesignation, which is at Annexure D, page 82.
Should be.
page 82, my lords. Translation is at 86, sorry. my lords. They record everything. And then, my lords, please come to page 90. On 10/1/23, my lords, they say that for CA's promotion, we will be considered. It is not a case of CA's promotion. This we brought to the notice of KAT saying that this is in contempt. The KAT, my lords, thereafter gave them one more opportunity which your lordships would get at, my lords, page 39, annexure B, which is under challenge before this court in a contempt proceedings. Page 39, annexure B, my lords. They gave them 2 months to comply with the directions of the tribunal and the High Court. Challenging this, they have filed a writ petition. The first order also, but now we have been struggling from 2010 onwards, since our appointment. Now, it's not a case, it's only a case of redesignation. What the state government is trying to do is, instead of redesignation, they want promotion. Now, so far as PhD is concerned, my learned friend said we have not obtained the PhD. Now, let's please come to page 290. I have obtained, both of us have obtained, my lords, 290 and 291. We have obtained PhD on 19/1/21 and 15/3/2021 with a 4 years delay. So far as AICT's notification about reversion, my lords, your lordships would get that. 2016.
Page number 268.
My lords, page,
55 of the earlier judgment.
yes.
68. 55 of the earlier judgment. 7 years.
Yes, but please come to, my lords, in this AICT notification itself is there at page 92. It starts at 92.
Is what is.
Yes, extracted, my lords. But at page 101, your lordships would get the relevant portion. 101, item 53, my lords. It starts whether assistant professor redesignated, your lordship gets that. As associate professor with effect from 1/1/2006.
See what is specifically extracted.
Yes, my lords.
In the judgment.
This is all what they have to do. They are now trying to say, we'll consider you under CA's promotion.
And then it is stated that in view of the above clarification, even if the candidates do not earn PhD within 7 years, they only lose increment until they earn PhD. Therefore, designation pay scale will not be impaired. Even otherwise, as can be seen from the records, petitioners were appointed to post as assistant professor in 2010, etc.
Para 3216.
The time to acquire PhD is from September to November 2016 to earn PhD. Therefore, it is premature to draw an inference against petitioners in this regard. Dun pleaders strenuously contended, etc., etc.
Para 30, their arguments were rejected.
33. In view of the above, there is no dispute that the petitioners were appointed as assistant professors. According to said notification also, that they are legally entitled to designation of associate professors immediately about 3 years from, must be after, 3 years from the date of their appointment, September to November 2013. The government has not produced any material before the court to show that government has given designation of associate professors to the petitioners as on September to November 2013, if the petitioners are otherwise entitled to the said designation. It is also to be noted that when matter was pending before the Karnataka Administrative Tribunal, government was in haste to pass an amendment to the recruitment rules, rescinding its earlier amendment dated 18/12/2012 and 11/3/2013, 29/1/2014 without considering the above noted entitlement.
Para 40 at 278 is the last.
Therefore, it is clear that the government, by invoking powers under Section 3 of the KCS Act, is justified in amending the rules, upgrading the assistant professors to associate professors and giving it a retrospective effect from 1/1/2006. When such order is passed by virtue of 2 amendments dated 11 and so on. So government would not have passed the subsequent orders withdrawing the said notifications prospectively by its notification dated 29. That too, when the matter was sub judice before the court without any opportunity.
That's the only thing.
View of the stand taken by the government that the petitioners are eligible for the post of associate professors from September to November 2013. Order passed by the government dated 9/1/2013, presenting its earlier order dated 18/10/2012 and 11/3/2000 has become in purpose. No need to pass any order in this.
They have to simply redesignate us. Now, my lords, what they do is they are trying to push us under the CA scheme for promotion, to attend interviews, to consider my eligibility. That is not,
Where you appoint.
lords, we were 2010, my lords. In my list of dates, we have set out with the para numbers and, my lords, document cross page number reference also.
In 2013, you would be entitled to redesignation.
Yes, ma'am.
But you would not be entitled to the AGP
Yes.
if you do not acquire the PhD within 7 years.
7 years. And even if I do not obtain within 7 years, if there is a delay, for the delayed period, my lords, I am not entitled for the KG. That's the,
So
my lords.
Is that the situation?
Lords, what happened till Lords, 2012. Lords, 2010 when PhD have been obtained subsequently. In 2000, that specific date is 10/3/2010. From then onwards, to designate itself, there was a necessity of PhD. So that perhaps stand corrected, ACT was not party before the honorable court in that case. Lords, otherwise this regulation would have been brought to the notice. There is a possibility. Now I cannot say that the court, the order is wrong because I cannot go beyond that. But will here only glitch, I think perhaps on which the state is also relying on it. As on the date of their appointment and the promotion that they were entitled to as they were promoted, as on that PhD was a mandatory requirement which they did not have. And this is missed out. So now, my lords, in this, how to come up with a solution is an issue. But that is one glitch, my lord, that is there in there. If as on from 10/3/2000.
Is that the reason the state says for rejection?
Yes.
That
No.
specifically is.
No, that is not.
No.
Lords, please come
My
to my
lord, the rules
list of
may be-
dates, my lord.
Your lordship asked for the date. My lord, the regulation came into effect on 5/3. My learned friend mentioned that.
I have, my lords, please.
Regulation
there.
came into effect on 5/3/2010. They were appointed subsequently in September 2010 and October 2010. So they were, these rules were applicable, my lord, at page 167.
Now, why was that not?
My lord,
Lords,
in the
It was,
earlier-
my lord, please see my
My
list
lord-
of dates.
my lord,
They
your
miss
lordship
out the
will-
crucial date. That's what is happening here. My learned friend says, my lords, 5/3/2010, ASCT regulations came in, my lords, regarding redesignation. We were appointed on 30/09/2010, 13/10/2010. The next crucial date is 7/3/2011, when the state government adopted the AICT scale. That is then treated as incumbents. So my appointment does not, that is what is crucial, my lords.
And 18/10/2012, CNR rules of DTE were.
To
amended
reflect redesignation. And that is what they sought to withdraw, which this court said you can't do that.
But may I take
11/2012 is the AICT regulation stating that those assistant professors joining
cash
service
regulation.
after 5/3/2010
Are required to obtain
required to obtain PhD.
in addition to.
My lord, may I
And
just,
being considered by the
My lords, that's exact.
earlier round.
Yes, if your lordship saw that.
Regulation, the qualification, here for associate professor PhD was made mandatory. In
No,
2010
as-
itself.
No, 5/3/2000, your,
Then.
the
5/3/2010
regulation is in 2012.
No. I'll 5/3/2010 is the AICT's regulation, my lord. Lords, if you get it, A4, 165 page number. That is AICT regulations on pay scale, service condition, qualification for teachers and other requirements staff. And technical institution in bracket degree, bracket close, regulation 2010. in that, lordships are to see the post of
178.
lords, 166.
178, page 178. 178, you get it straight away.
There for the post of associate professor, completing 3 years in service of AGP so and so, you lordship 167, my lords, you lordship will get Roman 13.
Associate
Clearly
professors
says
completing 3 years.
Because there as a condition, the PhD as a prerequisite was made from there itself. That is
13
why, my lords, in
Just a moment, just a moment. 13 is associate professor being redesignated as
It is
professor.
12, my lord.
So it must be
12.
12.
Before that.
Assistant professors completing 3 years teaching in AGP of so and so shall be eligible, subject to other conditions.
That is the
may be
keywords, my lord.
prescribed by-
Subject to other conditions is very relevant.
Subject to other conditions that may be prescribed by AICT as applicable to move to the pay band of so and so and to be designated as associate professor. Where is the other condition below?
My lord, the other conditions, your lordships may come to 2012 at page 44.
That exactly is the
Indeed.
issue.
My lord, it
That
says
comes only in 2012 with retrospective.
with retrospective effect. Indeed.
Yes. That
At
can
page
be said,
44,
it
my
is-
lord.
If as a matter of fact, it is not provided on 5/3/2010, that PhD is essential qualification for redesignation. Then the fact that a later regulation provided PhD will not help.
What assumes significance is the words, the other conditions, my lord.
Please
That
see.
may be prescribed.
Please see this, yes, please see paragraph 4, 166.
Assistant professors
professor
who do not have PhD
Have PhD or a master's degree in the relevant branch discipline of a program shall be eligible for AGP of 7,000 only after completion of 6 years service as assistant professor.
Yes, but they
They have the master's degree in the same
they have the
discipline.
master's degree,
They do not have PhD.
they did not have PhD. as an-
Absolutely. Therefore, going by your regulations on 5/3/2010, they could be redesignated. They would be entitled only to the AGP, which is lesser. That is
Yes.
all.
Yes.
They are entitled to redesignation. This is the end of the issue.
My lord, may I just take your lordships to
Yes.
182, my lord. My lord, it will become a very anomalous situation because, my lord, what is sought to be projected is the AGP scheme is different from the CAS. In fact, the AGP scheme is a career advancement scheme which is considered, which was brought into effect as an alternative to promotions, my lord. The reason being, this was a non-vacancy based way of upgradation. And this prevented a lot of litigations. That was the objective behind bringing this into effect, my lord. The lordships will see it.
We cannot rethink what this court
I'm just pointing it out.
has thought in an earlier round of petitions, where you were given all.
Your lord, it will become
opportunity.
very clear, exquisitely clear at page 182, because what was stated in the regulations is extracted. It is in a tabular form in page 182, which is the government order adopting the 2010 regulations, my lord. Your lordships will notice they stand at stage 3 at academic grade pay, which is 8,000 at the last column. My lord, now what they are saying, they want to move to the higher, this one, next stage of AGP, which is assistant associate professor, which was
All
my lord,
this
and
is
column.
going behind
They
the
wanted,
earlier round of petition,
Lord,
we
they-
cannot go.
they want to become associate professor.
That redesignation has been found in their
My
favor.
lord,
in the earlier round.
AGP is associated with the word, with the redesignation. So if to say that they will be
It's not the situation.
not entitled to
We see
increments,
the AGP.
please,
We see the AGP at 3.
please,
It is 8,000.
8,000.
And for 4 is 9,000.
Indeed, madam. Now they are saying that they are not entitled to AGP, but they are entitled to redesignations,
That
which
is
would
what
mean
this court, which is what this court held in the earlier round.
madam, the
Worked
AGP
by-
of 9,000 is associated with
PhD
the
ಬಂದೇ ಬರೋದು. PhD
post of
ಬಂದ್ಮೇಲೆ.
Specifically is what this court
ಹೌದು
held.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
madam, that has been noticed in the contempt proceedings.
Yes.
And it has been held that it cannot be read without noticing the fact that it was subject to other conditions. That is what the contempt, in the contempt proceedings, the
Yes.
Honorable High Court notices. In fact, the undertaking is also noticed in para 2 itself. Your lordships may notice at page 12, my lord. Based on the undertaking, it was held by the this honorable court that the relief sought had become infructuous. That has been clarified saying that it cannot be read as meaning without the other conditions being prescribed on a subsequent date. My lord, may I read para 2, my lord?
Other conditions on a subsequent date that is stated?
My lord, may I just start from para 2, my lord?
Mm.
Because the undertaking is very importantly, the grievance of the complainants revolve around other part operative portion of the said order, which reads as under. In view of the stand taken by the government that the petitioners are eligible for the post of associate professors from September to November 2013, the order passed by the government dated 29/1/2014, rescinding its earlier order dated 18/10/2012 and 11/3/2013 has become infructuous. Hence, there is no need to pass any order in this regard. The learned advocates appearing for the complainants vehemently argue that the above text of the order, coupled with observation at para 29, constitutes an undertaking given to the court that the complainants would be redesignated as associate professors, and despite demand, the same has not been complied with. Since there is no justification whatsoever for the said non-compliance, the same will be a willful disobedience, and therefore the accused respondents will be summoned and tried for the offense. Well, I'll come to para 3. After service of notice, the accused persons have entered appearance through the learned HCGP and register the complaints by filing the statement of objections in CC so and so. The same has been adopted in the rest of the cases. Gist of the submission of the learned HCGP is no unconditional undertaking for the so-called redesignation. But this is what is in any event, there is no unconditional undertaking for the so-called redesignation. One of the essential conditions is candidates possessing PhD, that qualification being lacked, the complaint of willful default non-compliance has no substance. So contending, the learned HCGP seeks dismissal. Having heard the learned counsel for the parties and having perused the complaint papers, we decline indulgence in the matter for the following reasons. A careful perusal of the operative portion of the division bench order does not inspire us in any inspire us that any unconditional undertaking was given by the accused persons, so that for its violation, all they can be hauled up for contempt action. Paragraph 29 of the division bench order reproduces the tabular column at item 53 of ACT notification dated 4/1/2016. A reading of the paragraph gives an impression that there is no requirement of PhD for the redesignation in question. However, a deeper examination unmistakably shows that such a concession was confined to such of the assistant professors who were redesignated with effect from 1/1/2006. Admittedly, all the complainants gained entry to the positions only much later. Therefore, they cannot draw any milk from the said notification or the observation made in paragraph 29 as rightly contended by the learned HCGP. The learned HCGP drew our attention to the AACT notification dated 8/11/2012, where regulations 2012 have been framed under section 23(1) read with section 10(1) and 4 and 5 of All India Council for Technical Education Act 1987. Though the title clause of the regulations give an impression that they are confined to cases of career advancement scheme, a bare look at the text of regulation 3 dispels the same. They are applicable to other promotions as well. Regulation 3.8 reads as under: assistant professor completing 3 years of teaching in grade grade of 8,000, stage 3,
Which is very
shall be eligible subject to the qualifying condition and the API-based PBAS requirement prescribed by these regulations to move to the pay band of rupees 37,400 to 67,000 with next higher grade of 9,000 and to be redesignated as associate professor. And what is highlighted is, however, those joining the service after 5th March 2010 shall have also earned PhD in addition to the above mentioned requirements to move to the stage 4. They were all appointed after 5th March 2010, and they are bound by this condition because in the 2010 regulations also, it was mentioned that it was subject to other conditions to be prescribed by the, and that has been clarified in 2000.
cannot be, would have been other conditions prescribed at the relevant date.
That finding has not been given in the
Notification.
my lord.
7/3/2011, annex page 181.
In fact, my lord, it was
There
due
was
to the dearth of
contention that there was such another condition at the relevant date. Now, what is the order of rejection? Which is the order of rejection which was under?
That's that endorsement your lordships would get. Annexure E, that's D at page 82. It starts at 82. I'm sorry, the translated copy is at 86. It's at 89, if your lordship comes, the reasoning starts. After, my lords, accordingly, they called us for a screening thing. After that, my lords. Para 3.8 of AICT Regulation 2012 to move to professor from post of assistant professor acquiring PhD is mandatory. Service after 5th March 2010 shall also have to be earned PhD in addition to above mentioned requirements to move to stage 4. Then, my lords, the High Court's order is again extracted. Then, my lords, in government order dated 10/1/2020, relaxation has been given till 7/11/2015 for API score as prescribed in AICT Regulation 2012 dated 8/11/2012 and other conditions stipulated in the regulation remains the same. The screening, my lords, this AICT regulation which they are referring to relates to CAS, Career Advancement Scheme. Screening cum evaluation selection committee has stated Shri K. Pradeep Kumar, assistant professor, has completed his PhD degree on 9/1/2021. Screening committee evaluation selection committee stated Shri so-and-so has completed his PhD degree on 15/3/21. Then 7th pay scales have been implemented in AICT pay notification dated 1/3/2019. But Pradeep Kumar and so-and-so have completed the PhD after 1/3/2019. Hence, there is no provision to give CAS promotion in 6th AICT pay scale to the said assistant professors in accordance with the rules.
Just a moment, for redesignation, page 88, it says for redesignating assistant professors to associate professor in the 6th pay scales or to give promotions, acquiring PhD is mandatory as per 3.8 of AICT regulations 2012. Where is that?
My lord, at page
44 minutes.
8, my lord.
Page 44.
3.8 at page 4. It starts at 44. Relevant
Assistant
portion is at
professor
40.
after completing 3 years teaching in the grade of 8,000, stage 3.
And that is under
Shall-
CAS.
Yes, shall be eligible, subject to qualifying conditions and API-based ECA's requirements prescribed to move to the pay band of 37,400, 67,000 with next higher grade of 1,000 stage 4 to be designated as associate professor. However, those joining
They
the
have referred
service
to
as
this
on
regulations,
March 2010
2016
shall
regulation.
also have earned PhD in addition to the above mentioned requirements to move to stage 4. Then why did you issue this clarification in that all, if they don't have PhD, that the only consequence would be
In fact, they have given an
That was in 2006. For those who have completed joint service in
endorsement.
2006,
Let's go to
My lord, it will
for
become,
them,
well, how can you say that those
No, no,
joint service in
there are-
2010 would be
I got lordship correctly. Lordship is asking about the reference to this, the
3.8?
judgments. In 3.8 million is a new regulation that
So
came
like
up in
it's in
2012.
It is in 2012.
Well,
It says that
Fine.
persons who join
So
service.
because what happened is that before that, the condition was not there. Lordship, you could be, previously, there was possibility that those persons could get promoted without obtaining PhD, but the timeline was given. And it was in that respect, in what context that particularly the time was given, which was referred to in the writ petition, previous writ petition. For those who have completed their joint service in the year 2006, for them time is given. If that extract
That
is
notification that in which your paragraph 53 is extracted is on 4/1/2016. Even there, you do not point this out.
Yes, Lord's
4/1/2016.
Lordship may kindly see a 268. In that, Lords, whether the assistant professor be designated as associate professor with effect from 1/1/2006. For that condition, for them, a clarification, it has nothing to do with the present scenario. In this case, in what context that was quoted there, that itself says that because prior to 5/3/2010, that condition was not. Hence, this was in that context. If Lordship may kindly see what whether assistant professor redesignated as associate professor with effect from 1/1/2006, who are not able to complete the PhD in 7 years from the date of joining, so direct CAS will be reverted back. Such candidates will be required to complete PhD within 7 years from the date of. This clarification is in the context of those who have joined in 2006. Admittedly, in this case, all the petitioners have joined after 2010. And my lords, in 2012, a new CAS regulation was notified. There it was clear.
Is it your case that it is applicable to this redesignation also? Is it your case that it is applicable to the redesignation as found by this court also?
In this context, my humble opinion, yes, because what happens is, as on that day, their redesignation had happened only as per CAS regulation 2012. Because they were associate professor, assistant professor. They admittedly completed X number of years.
Entry is assistant professor. All
Entry is
lecturers are
assistant professor.
redesignated.
From there, they were promoted to the stage of associate professor, rightly or wrongly, only under 2012 regulation.
It is not, my lords, it's
Because
not promotion.
As on the date, because they were.
Lords,
No, now,
in fact,
after this judgment, my lords, the question for consideration is their designation was as associate professor was withdrawn, and the government had sought for recovery of the amount, or it has tried to start a recovery. That is set aside. And in that, government statement or undertaking is recorded that from 2013 onward, they were eligible. Hence, my lord, the government is bound by that.
All of them, none of them had PhD qualification as of that.
As on that. All of them have got it.
Even
now.
thereafter, the government comes before the division bench and says they are eligible from 2013. Then they appear to realize their mistake. What should be done? 2013 judgment,
I'll only-
the early judgment
I would
would have been subjected to a
I may
review on that.
clarify, my lord,
You
if-
take it up in.
If it is accepted
it
that
may not
they are
be
not entitled to increments, but only redesignation, it will lead to an anomalous result. Because the increments are associated with redesignation.
You are bound by the judgment.
My lord,
It is a matter of your own making. No, but what can we do?
The contempt,
only bring
the
about a
contempt
slight-
proceedings, the court holds that the undertaking cannot be considered without ignoring the condition. My lord.
Will not make any difference because here the judgment stares at us.
There was a slight difference, but I would still say there is no
Lordship
mistake in the
may-
judgment. We were treated as incumbents because the state government adopted this 5/3/2010, my lords, the regulations in 2011 and gave us the benefit. That's why we are treated as incumbents and given the benefit. In fact, AICT, my lords, of course, during pendency of all these matters have come out with another clarification notification of 20th May 2020, if your lordship just sees.
What does it say?
There also, my lords, they've separated CAS and the court. Please see that, my lords. Page 7. Sorry, the author, I'll just give 1 minute. Lords, in that, please come to page 7.
Perfectly aware. An order in a contempt cannot be construed as a binding precedent.
Indeed.
An order in a contempt only decides
For that particular case.
specifically
Yes.
for that. Here, as far as the earlier judgment is concerned, because you have taken it up to the Supreme Court and SLP has also been dismissed. That has more value as far as we are concerned than the order in the judgment. I mean, the order in contempt. Therefore, there is a finding there that they are, and on the basis of some submission made by you, that from 2013 onwards, they are eligible for the redesignation. How do we get over?
Lord, may I just point out from page 182, my lord.
Just a-
Lordship
just
notice
a moment.
page.
Lords, in that, your lordship may
Lords, simultaneously, can I request your lordships to just take page 88 in the writ petition, my lords? The impugned endorsement referred to that clause 7, my lords, to reject mine. Your lordship sees the heading there, CAS issues of upward movement, your lordship gets that, my lord. Above that, your lordship should get serial number 5. Issues pertaining to candidates upgraded with the condition of obtaining PhD. So that also the KACT says we are not entitled for increment only for the period during which you don't get PhD.
Here again, it is reiterated.
It is again reiterated. But the state government, what they do is, my lord, they ignore this 5, refer to 7 and issue the impugned endorsement.
Immediate answer would be 5 would be in respect of those redesignated
That-
as on 2000.
Wording is not there.
That wording is not even in this also there is no wording. In fact,
My lord, the question is, these are clarifications. They will not have an overriding effect over regulation. If your lordship looks at the,
But we,
if your lordship looks at the regulation, my lord, it will be impossible to accept it will be impossible to do what they're asking. They don't want increments, they want promotion. It's a very absurd proposition.
It is not absurd.
Where they don't want increments, but they want promotions. My lord, the increments, my lord, let them point out how is it even possible.
came before this court and said we are doing it.
My lord, that has
That
been,
you are bound.
that has been,
My absurd contention was accepted even by the Supreme Court.
but it is only subject to the other conditions, my lord. My lord, the government also, my lord, with respect, my lord, it could not have, my lord, the AICT regulations are also not very happily worded. It's a little cryptic when they say that other conditions.
You should have taken a contention that the AICT was a necessary party to the
Last
regulation.
time order copy.
If there is a,
Division bench.
instead of coming forth and making submissions.
The government could not probably have anticipated that in 2012, the other conditions would come into place, my lord.
By the time the judgment is rendered, when is
The
it?
judgment is rendered thereafter.
The 2012 regulations are already in force.
My lord, if your lordship sees the table, all the increments are associated with the redesignation. They cannot say that we don't want increments, but we want redesignation.
No, I don't know why my learned friend is saying that. I said, if you don't get PhD within that 7 years, we will not get that.
AGP.
Yes, but they
That's
get, but
I
they're
don't
saying
know.
they will get redesignation.
It is, my lord, that is what was contended. All these things are looked into.
My lord, even if it's not AGP scheme, my lord, it's based on, one gets increments based on the service rendered for a period of time. And thereafter, based on the number of qualifying years of service, promotion is given. It's very anomalous to think that
What is your-
increments,
Now, what is your petition about? Is against the direction to reconsider?
the direction before
A and B
the,
have
by the
question.
KAT was to comply with the order of the High Court, ma'am, which was the relief which they had already got.
So clear
They
that
were
the
parties to
AICT
that.
regulation itself stipulates the such of those assistant.
So they're not, what I'm saying is
Were
that
redesignated, who were designated as associate professors with effect from 1/1/2006 and who are unable to complete their PhD within 7 years from date of joining would suffer the stoppage of their annual increments to PhDs earned, and they would not be reverted back. Given the clarification of the AICT, it is necessary that the accused have to comply with the AICT guidelines and accordingly to initiate steps to withhold such increments from the complainants instead of their reversion. The compliance affidavit given in the is not accepted. Order dated 1/1/23 issued by director is not in conformity with the AICT regulations. Therefore, the accused are given 2 months' time to fully comply with the requirements. Yes, AICT, you want to place pleadings on record in this matter?
My only submission is that as of that 2012 regulation, it is missed out. I can only, if I have already missed the bus, situation is missed the bus, there whether the lordship can now interpret whether the judgment is right or wrong, my lords, is the issue here. Otherwise, my lords, if this contention was taken in the 2016 itself, my lord, there was a possibility that court would have ordered differently and they would not have got that benefit. Now, only redesignation to them, my lords.
Too late in the day.
there is no estoppel against law is what I would submit, my lord. No, they cannot say that the clarification will have an overriding effect over the regulations. And they have not challenged the regulations, my lord. They remain on the regulations are not challenged.
But the learned government advocate extensive. We have also taken note of the directions of the tribunal and the orders passed in contempt, which are challenged before this court in these proceedings. However, in the light of the clear stand, it is vehemently argued by the learned government advocate that the AICTE regulations of 8/11/2012 are clear, specifically clause 3.8 thereof, and that only those and in respect of persons appointed after 5/3/2010 as assistant professors. 5/3, yes, only those who had earned PhD would be entitled to move to the pay band of rupees 37,400, 67,000, with the next higher grade of rupees 9,000. Within bracket stage. However, the contentions are clearly against the findings of this court in an earlier round of repetition, as is evidenced by Annexure 9, where the government had specifically taken a stand at paragraph 40 that the the government had suffered an order to the effect that by virtue of the two amendments dated 7/3/2011 and 11/3/2011, the government could not have passed the subsequent orders withdrawing the said notifications prospectively by its notification dated 29/1/2014. And had also, and this court had also held that the government order dated 29/1/2014, rescinding its earlier order dated 8/10/2012 and 11/3/2011 had become infructuous. Full stop. Though the learned government advocate contends that in view of the AICTE notifications, AICTE regulations, which were notified on 8/11/2012, the only conclusion would be that only those assistant professors who were redesignated with effect from 1/1/2006 would be entitled to the benefit of the clarifications as issued by the AICTE. And since the petitioners were persons who were appointed after 5/3/2010, they would be subject to the subsequent regulations dated 8/11/2012, and without challenge to such regulations, the claim now made cannot be allowed. Full stop. However, having considered. Yes, and that the redesignation had occurred after the 2012 regulations. The present, the benefits that sought for cannot be granted. Having considered the contentions advanced, we notice that the aspect with regard to the redesignation of the petitioners had been considered by this court in Annexure A9. this court had found that the petitioners were appointed as assistant professors during September to November 2010. It was a stand of the government before this court that they are entitled to redesignation as associate professors immediately after 3 years from the date of their appointment, that is from September to November 2013. It was in the above circumstances and that they had not been granted such redesignation. It was in the above circumstances that this court had held that the withdrawal of the notifications issued by the government granting the benefit of the redesignation retrospectively by order dated 29/1/2014 was bad in law. The said matter was taken before the apex court and the SLPs stood dismissed. In the above circumstances, we are of the opinion that it is not now open to the government to take a diametrically opposing stand to the stand taken by the government in the earlier round of litigation and which has been subjected to a decision by this court. The above view of the matter, we are of the opinion that the orders passed by the tribunal do not warrant interference. The petitions fail, same accordingly stand dismissed. We understand the difficulty, but then we are unable to do anything. So it's been specifically considered and yes.
My lord, serial number 36, my lord. Seek adjournment, my lord, for serial number 36 to 21st or 22nd.
Serial number 38 also.
Date, may
The dates, please wait for the dates.
Your lordships kindly,
Not till December end comes. Please be reasonable. Please talk to each other, come up with a date we'll consider 2:30.
with your lordships kindly. Let's 25 minutes. A Passover was short minutes. Your lordships have adjourned it. There is some urgency. If your lordships could kindly consider having the matter on Monday. My lords, I'm sorry, my lords, I was on my legs in another 20 serial number.
Yes.
My lords, the KAT, my lords, is imposed a cost of ₹1 lakh and has, my lords, further directed, my lords, inquiry. My lords, KAT has prejudged the matter, my lords. Now, there is no finding of fact. Now, if with that order, my lords, if at all I were to go before an inquiry, my lords, it is, there will be no transparent and fair inquiry.
This is the case of
Medical reimbursement. Yes, my lords.
Son's dengue.
Yes, my lords.
Have it immediately after holidays. Till such time, don't press. Yes.
Right, with kind permission.
Government at it's time to get instructions, list immediately after holidays, give a date. Till such time, further proceedings shall not be precipitated.
Deeply obliged.
Serial number 28, ma'am. It may have it on Monday, ma'am. Monday or Tuesday. 28. Some medical emergency. Even I have moved the memo there.
The day A7 of court delinquent, we'll have it immediately after holidays. Yes. Yes. Immediately after.
Court officer, madam. Madam. Madam, 28 ಏನಂದ್ರು?
Orders 230, till number 50.
Pass over, we'll make an attempt whether it's possible today. Pass over.
51, Mallikarjun Reddy.
Usual orders. Whatever is relevant. List after holiday. 52 also say, yes.
53. English translation.
53 also say.
54, Mohammed Shamil.
R1, R2.
8 may be 20 selection, my lord.
After vacation, there's an interim order of stay, my lords.
Therefore, my lord. Yes, ma'am.
List immediately after vacation, give a date after vacation.
Interim order has to be extended.
30th shall remain in force till then. Till then.
October.
October.
55, Anubal.
Here for petitioners. This matter, my lord, there is some urgency in the sense, my lord, the order passed by the Honorable KSAT completely misses the point, my lord, between the actual appointment and, my lord, the appointment process initiation. So I, my lord, was one of the contenders for this selection process. And one of the one who was selected, my lord, his name appeared in the final selection list. There is no, my lord, dispute about that. But after that, my lord, 2 other steps are contemplated. Once, my lord, the final selection list, my name is included in the final selection list, I have to give medical records, then, my lord, other qualifying documents, and then, my lord, the selection process completes. But unfortunately, the admitted fact is, my lord, that candidate who is selected has not gone through the process of actual appointment, but he had a right to be considered for appointment. But in the judgment, my lord, that is passed, it is held that mere appearance of the name of the candidate in the selection list suffices the process of selection. And on this basis, my lord, the Honorable KSAT says that you are the next candidate in line. He has not reported, but selection process is over. The whole selection process has to be redone. You don't get any opportunity to be selected. This is, my lord, and the order contradicts itself by saying the rule, I'll read, my lord, if lordships permit me.
Rule is 11.
Rule 11.
11.3.
Yes, please, my lord, please, my lord. May I persuade your lordships?
Only when appointment, there is a
Yes.
judgment of co-equal bench.
Yes, coordinate bench of this honorable court, my lord. The coordinate bench judgment also is sought to be distinguished, saying that the honorable court did not notice the rules. The overruled, KSAT overrules. Lordships may see, my lord, page 29, ink page 20. I'm sorry, in that rule, your lordships are aware, my lord. 11, 4 may kindly be first seen, my lord, if I may persuade your lordships to see holding competitive examinations. Lordships will see government may order, amend so and so. Commission will invite applications in the prescribed form. Then candidates, 11.4.3, the candidates who apply for competitive examination shall clearly indicate in their application forms the services post for which they are considered for appointment. They shall not be considered for such service or posts which are not preferred by them. This is, my lord, one aspect. Then your lordships may see 11.3, your lordships are aware. Well, says, the 11.3 proviso says, provided that no candidate shall be appointed unless the government is satisfied after the inquiry and verification as may be considered necessary that candidate is suitable for appointment. 12, my lord, says, inclusion of a candidate's name in the list itself does not confer any right of appointment. This is, my lord, the clear statutory position, as against which my lords will now see, my lord, page 29 of the 29 of the order, my lord. Order begins from page, my lord, 20, and the discussion on this is, my lord, page 29, para 10, my lord. May I read it with your lordships? Para 10, my lord, on ink page 29. Lordships get it.
Yes.
My lord. No doubt, the applicant relying on the previous judgments rendered by this court in application number so and so, and also the judgment rendered by this court in so and so, decided on so and so, on reading, the relief portion of both the judgments are not helpful to the case of the applicant. Subsequently, the amendment made by the state government and government order was not disclosed in the said judgment. This is not the, then it is settled law that selection process shall be considered by existing rule of law as on the date of recruitment notification published by KPSC. Lordships may see the self-contradiction. One, it says, my lord, there is supposedly some amendment brought about, which is not a fact. Even if the amendment is brought about, it is effective from the date of amendment. They write, the Honorable Court itself, the tribunal.
Apart from inclusion in the list, he was not issued with an order of
No, my lord. That is the clear, there is no dispute on that.
The objections are already filed, my lord. There are some office objections on the objection copies. I'll serve the copy on the other side. May be called on Tuesday, my lord.
May I, my lord, seek till then that no fresh appointments will be made. The application is also filed, my lord, for stay. That's all I'm asking. Let them undertake that they will not.
No, has new
Application.
appointment,
Yes.
has new appointment
Reject.
process been initiated?
Sorry, no, they are now saying, Lord, that they will start the de novo process.
They have not started the de novo.
Yet.
List on Tuesday?
Tuesday, my lord.
But till then, I don't know, my lord, if it initiates.
On Tuesday, in the meanwhile.
Yes.
Fresh recruitment process shall not be initiated till.
Right.
The facts are not in dispute.
No,
Facts are.
that is clear. And selection, he has not appeared. He went for IPS. He did not want this post. He went for IPS.
56, Siddhayan.
Yes, weeks time. If it's only English translation, usual orders. 57.
57, Naveed Ahmad.
For the appellant.
What is the office objection?
It is not for the office objection. The last time we had made the payment and the possession was given. Now the, with request, with regard to the payment, extra payment, GST and memo of calculation was filed.
What do you say?
Data payment they have submitted to produce the document from GST and TDS.
Documents, TDS.
TDS and GST.
Sorry? That has been produced?
Both have filed the memo of calculation. Only with regard to TDS and GST, we have to file some documents. I need some time.
Just a minute, we have to hold this.
Date may be.
Yes, please give a date.
21st.
Much of it.
58, Prashant Viji.
Eligibility.
The vexed question, as Lordship will recollect, is if appeal is maintainable or should I go the writ way? I will only persuade Lordship to look at two provisions of Commercial Courts Act and then whatever is the.
Yes.
Kindly see section 16. The provisions of CPC shall in their application to any suit in respect of a commercial value of a specified value stand amended in the manner as specified in the schedule. The Commercial Court Division or the Commercial Court shall follow the provisions of CPC as amended by this Act in the trial of suit in respect of commercial dispute of a specified value. So what 16.1 and 16.2 should together mean is that to the extent that the Commercial Courts Act has amended CPC, CPC stands amended, and such amended CPC has to entirely apply to a commercial dispute. If CPC is to apply, kindly see 99A of CPC, which is untouched by Commercial Courts Act. And therefore I say 99A applies. 99A is under Part 7, which is appeals from original decrees. Though the subheading is appeals from original decrees, 99A refers to an order passed in an execution. That is an order passed under Section 47. So what law has done is an order passed under Section 47, to the extent that it substantially affects the right of the parties, though is not appealable under Order 43, is considered appealable still by reserving 99A. And 99A is untouched by the Commercial Courts Act. Therefore, my submission here will be the present impugned order is that undoubtedly is passed under 47. And therefore, DHOS 43, an order passed under 47 through 99A read with section 16 of the Commercial Courts Act should be an appealable order. I am in Lordship's hands. This is a vexed question. There is no judgment on this.
Order under section 47 reversed. Decision of the case is prejudicially affected without this generality of the provisions of section 90. No order under section 47 shall be reversed or substantially reversed on account of any error, defect or irregularity in the proceedings related to such order, unless such error, defect or irregularity has been prejudicially affected the decision of the case. Therefore, appeal does not lie here, but it's an order where his execution petition is rejected. In execution itself is rejected by allowing the application of the 47. Now, the maintainability of the execution is a question. Whether the execution is maintainable or not is to be decided. But that order of maintainability of the order cannot be an appeal here before this court under section 30. He can only avail a remedy of a writ petition to either restore his execution petition or otherwise. So appeal under the Commercial Court Act is not maintainable.
99A, kindly see from 96. Kindly see the subheading, part 7. Part 7 starts from 96. Part 7 deals with appeals and 99A is under the chapter appeals. So therefore,
99A does not specifically refer to an appeal.
it is an appeal because part 7 deals first with appeals from original decrees. That is from provisions 96 up until 99A. Then 100 to 106 is appeal from appellate decrees. Then general provisions relating to appeals to 2 sections and then 5 sections on appeals to the Supreme Court. So evidently 99A falls within the subsection appeals from original decrees. Now, though it's not a decree, an order passed in the execution petition which has qualitatively the nature of substantially affecting parties will, through the provision of 99A, become appealable. That's my contention because
We have no quarrel.
Yes.
Difficulty is 13.
That's right. Therefore, if 13 is to be read in a restricted way, what will happen today is merely because it is a commercial suit, a valuable appellate right will be denied, which is never the intention of statute. And that is why I read 16. 16 says that to the extent CPC is amended, the amended CPC will entirely apply. And if that is so, then taking away a valuable statutory right available to me by virtue of a certain reading of 13 will be incongruous.
Certain reading of 13 may not be.
No, Lordship will kindly see 13.
13 says.
Kindly see 13. 13 says 13.1 and 13.2. In fact, the
13.2 is the difficulty.
13.2 there is no difficulty. 13.1 proviso may be the difficulty that Lordship, that's what Lordship had pointed out last time. In fact, one of the drafting mischiefs in 13 is 13.1 refers to judgment and order and 13.2 refers to order and decree. And there are judgments to examine why 13.1 does not refer to decree and therefore whether decree is appealable or not. And therefore, there are courts which have clarified order is appealable, decree is appealable, judgment is also appealable. All 3 are appealable. Now, kindly see 13 proviso, provided that an appeal shall lie from such orders passed by the commercial division, etc., as amended by this act and section 37 of the Arbitration Act. Therefore, it is clear that order 43 orders are appealable. But whether order 43 appeals alone are appealable is the question.
Please see 2. Notwithstanding anything contained in any other law for the time being in force or letters patent of a high court, no appeal shall lie from any order or decree of a commercial division or commercial court, otherwise than in accordance with the
provisions of the act. That's why I refer to 16. Provisions of the act will say under 16.
Provisions of the act are 13.1.
13.1 also.
And the proviso.
Correct. That's right. So, of course, there is a difficulty there. 13.1A may, on the face of it, create a bottleneck for a 99A appeal. But 16 read with 39.1A and considering the fact that merely because something is a commercial dispute a statutory appeal can't be denied to a party, which of course there is any amount of literature to say an appeal remedy is not taken away by Commercial Courts Act. That's my, it's a really tough question.
Do you want a,
In fact,
on the point?
if Lordship reserves it and passes some order, if I have to go the writ way, I'll do that. But I will request for a return of finding on this.
Yes.
Grateful.
Yes, reserved.
Great.
On the question of maintainability.
Great.
Because he wants a speaking order. If he only wanted to,
There's some
because-
judgments which are referred.
yes.
Place it on.
Yes.
Great.
Reserved on the question of maintainability for orders.
59, Natraj Bala.
Week's time. 59,
60,
60,
Petition. The
that was to be heard.
matter pertaining to the recruitment for the post of motor vehicle inspectors, my lord.
Hmm.
My lord, as on the last date of submitting the application as mentioned in the recruitment notification, I possessed a valid driving license. Thereafter, so far as the conductor badge is concerned, it was renewed from time to time. My application was not, candidature was rejected on the ground that as on the date of verification, I didn't possess the driving license. And the settled position of law is that the renewal of the license dates back to the previous actual date of expiry, my lord.
When did you submit the application for renewal?
My lord, the last date for submitting the application was 4/2/2016.
Hmm.
I submitted the application well in time.
When did your license expire?
My lord, actually license is valid till 2029.
Hmm.
So far as the heavy transport vehicles, passenger vehicles are concerned, batch is required to be renewed for every 3 years. my lord. After the last date of filing the application but prior to the verification, it was expired, badge was expired, and subsequently it was renewed, my lord. And that was not considered. And in identical similar facts, my lord, the Honorable Tribunal was also pleased to allow the applications filed by some other applicant in the very same recruitment notification. And in this case, my case, my lord, application came to be rejected.
Is there any judgment of this court on the point?
Please, ma'am, I mean,
With regard to this badge,
please, ma'am.
renewal of the badge? You had made an application for renewal at the relevant time? No.
Please, ma'am. It was not.
You had not made even an application for renewal?
Please, ma'am. Even my humble submission is, even as on the date of filing the application, I didn't possess the valid driving license. The qualification and eligibility is required to be considered as on the date of the last date of submitting the application. As on the last date of submitting the application, and as on this day also, my lord, I possess the valid driving license. And this is the law settled by this honorable court also, my lord. May permit. Kindly pass.
This is in a compensation case.
Please, ma'am. That
This is in a compensation case.
compensation.
What is the finding you're relying on?
Para 25, my lord. A coordinate bench of this court in the case of KG Srinivasmurthy versus Habib Khatum, reported in 2002 ACJ 557, has observed, after referring to section 15 of the act, that if the application for renewal is made within 30 days after the date of expiry of the license. The same shall be.
Exactly was a question. Did you have a case that you had submitted an application for renewal
Please.
and it was pending when you, when the verification happened? Do you have such a case?
Please, it was, my lord, as on the date of verification, I didn't submit the application for renewal. Subsequently, my application was renewed. My license was renewed. In fact, only insofar as the badge is concerned, my lord. Insofar as all the 4 driving permission for driving the 4 types
What
of
is the
vehicle,
qualification?
2029.
What is the qualification in the notification?
Qualification is I should have possessed the driving license of light motor vehicles, heavy passenger
For
vehicle,
the badge is also required.
heavy passenger. As on the
Yes.
date of submitting the application, I possessed my lord.
Will not do.
I mean,
On the verification, if you had actually made an application for renewal or for a reissue and it was pending, then this decision applies.
Yes.
If you had made an application for renewal or reissue and were awaiting it as on the date of the verification, then the decision applies.
That's
Not otherwise.
they are saying they are based upon the date of verification, my lord.
Whatever the date,
a-
you, from the date of submitting the application till your appointment and the.
No, immediately after verification, it was renewed from.
Consider.
Immediately after verification, it was renewed, my
Yes.
lord. And I'm one submission, sorry.
Hmm.
And honorable tribunal in identical matter, my lord, much prior to this order.
It's quite another matter,
Please,
which is why we asked you, is there any judgment of this court on the point?
please.
That
And
the
they have referred. to-
Tribunal has
No, no.
considered, unless we are,
Tribunal has considered the order of this honorable court and passed the order. Referring to relying upon the very decision placed before the honorable court, tribunal passed the order.
whether that applies is the question.
Please.
That in the facts of the case, maybe it applied.
My lord,
Yes, what do you say?
I request my lordship to come to page number 78, annexure A1.
Hmm.
My lord, the last date fixed to file the application was
Hmm.
4/3/2016.
Hmm.
Page number 78. my lord.
4/3/16.
Yes, my lord,
Hmm.
4/3/16
Hmm.
was the last date fixed to file the,
Hmm.
my lord.
4-2.
4/2/16.
Last date, sir, last date.
4/2/16 is the date of the notification.
Yes.
5/3/16 is the date.
4/3 is the last date, my lord.
5/3.
4-3.
4/3, my lord.
5-3 is for
5/3 for
Ah,
payment of-
4/3,
4/3.
Payment.
Sorry, sir.
my lord.
Hmm.
Now I request the lordship to come to page number 83.
Hmm.
My lord, in page number 83,
Hmm.
last but one condition, my lord, it's in Kannada.
Hmm.
ವಾಹನ ಚಾಲನೆಗೆ ಸಂಬಂಧಿಸಿದ ಲೈಸೆನ್ಸ್ಗಳನ್ನು
Hmm.
ಅರ್ಜಿಗಳನ್ನು ಸ್ವೀಕರಿಸಲು ನಿಗದಿಪಡಿಸಿದ ಕೊನೆಯ ದಿನಾಂಕದ ಒಳಗಾಗಿ ಪಡೆದುಕೊಂಡಿರ್ತಕ್ಕದ್ದು. That means, my lord, he has to obtain the license as on before the last date of filing the
Correct,
application. Now
correct.
I request my lordship to come to page number 112, annexure A6, my lord. A6, my lord. But,
Hmm.
my lord, at the right side, form number 7 is there, my lord.
Hmm.
Right side.
Hmm.
And in the bottom,
Hmm.
date of issue 25/10/2016, my lord. Right side, my lord, when it's near my lordship's right hand thumb finger. Got it, my lord.
25/10/2016.
Yes, my lord.
Hmm.
See, then, as on the date of filing the application, he doesn't have the valid driving license. The KPC has rightly rejected. But my friend is submitting before my lordship stating that,
Hmm.
at the time of verification,
Hmm.
I did not have the valid driving license. Even as on the date of filing the application itself,
It was not there.
yes, my lord.
25/10/2016 is the date of the renewal.
Issue, my lord, yes, my lord, the issue. That is the
one
renewal, my
submission.
lord.
Kindly consider
We'll
page
consider-
number 292, my lord, for a moment, my lord.
Hmm.
It's by mistake, I have enclosed that copy.
Hmm.
Page number 292, I have produced before the tribunal, my lord.
Hmm.
I have enclosed all the copies also.
292.
292, my lord.
Hmm.
292, where it is.
292,
Hmm.
this was filed along with the rejoinder filed by me before the tribunal, my lord.
Hmm.
Date of issue is 9/6/2009.
Where
Page number
292 does not show anything.
Yes, my lord.
292.
292 is a list.
No,
298, my lord. I think,
292, my lord.
if I am right.
292 in our copy is a list.
Yes, my lord.
Page 20 of the,
298, my lord.
290.
But in that also, in the
One
right
submission.
side.
Annexure E, my lord.
25/10/2016.
Annexure E, my lord.
Yes, annexure R4,
Yes, my lord.
25/10/2016 is 290.
No, it is not filed by me. Annexure E, the rejoinder filed by me before the honorable tribunal, my lord.
Counsel, please tell us the,
There it is specifically mentioned that date of
that's the page. It is not here.
292, my lord.
Sir, Yadida, we relate section, Is this the same?
9/6/2009, 9/6/2009.
My lord, 305, my lord, 305.
305.
Yes, my lord.
305, we cannot read what is written there.
My lord,
Their
305.
date of issue is 9/6/2019
90, but
and
valid for
it was
India.
valid. My lord, it was valid 8/6/2029, my
No,
lord.
that is not
One-
transferred,
one-
my lord.
Yes, we'll
One more,
consider.
my lord, one
One
submission,
after
my lord.
holidays.
It was for all four categories of the driving license.
No,
For
My lord,
hearing
the second,
after
next page is
holidays.
293, my lord, one submission.
Counsel, it is all factual disputes. We are not considering.
My
List after
my lord,
holidays.
please.
Yes,
1.5 years translation.
yes, relevant, usual order.
Venugopal.
Well, let's appear for the petitioner. Well, let's again, it has been listed on office substitution minutes. Though I have produced the memo with relevant translated copies on 29/8 itself, and heard the matter also.
Yes. List after holidays on a date. Yes.
Office objection may be overruled, my lords.
63.
Office objection.
Here for the petitioner. My lord, in this case, my lord, translation is not necessary because
Legible typed copy of page 178 of annexure A14.
because I am not at all arguing the case on merits of the case, my lord. Tribunal already allowed my application regarding imposition of penalties concern. My lord, regarding the same set of facts, there is a criminal case is pending. My lord, in view of the criminal case pending, my lord, my consideration for voluntary retirement has not been considered. My lord, second prayer before the tribunal was that, my lord, maybe my husband is, my lord, suffering from, my lord, paralytic attack and is totally bedridden. I have served 30 years of service. My lord, I will not take any retirement benefits. But I may be permitted to take the voluntary retirement. I will subject it to, my lord, the outcome of the result. I will take the benefits, my lord, because I am unable to work. I will be remained absent. If remain absent, my lord, I will be.
Make a representation, we'll say that it will be considered taking note of this.
I made the representation that limited purpose. I filed this petition, my lord.
Representation is made, then it will
Where
be
is the
considered.
Representation is already there. They rejected. Therefore, I approached the tribunal, my lord.
Yes.
My lord, once again, I will make my representations, my lord. They consider, my lord, sympathetically.
The government has to.
Yes, we can't do it in this, on this last date. List it immediately after holidays.
Please. Let him take notice, my lord. Get instruction.
Yes, then government advocate takes notice for the respondent and seeks type instructions list immediately after holidays.
1
Yes.
and 2. 1 to 4. 1 to 4, my lord, let it be a preliminary hearing, my lord, but my matter may be disposed of itself, my lord.
Yes.
Much over.
Government advocate, await service.
Yes, await service.
But,
65.
this matter was
64.
posted because, yes, my lord, notice has been issued, but contempt proceedings are pending, therefore. My lord, it's a
What is the
case.
finding?
My lord, ex-books entitlement to pension, my lord. They don't, even after getting the additional qualifying years of service and the 247A of the KCSR, they don't complete 10 years of qualifying service.
There are other connected cases.
No, this is the only one. Well, I have also pointed out it may not be, we don't have a good case against the fourth, the last respondent.
Therefore, with regard to 1 to 3.
Notice has been issued to everyone as of now. In fact, on the last occasion, I had conferred with the officers whether we have a claim or not, and they have agreed with me that they don't have a claim against the last respondent.
Have you issued served notice on the council who are appearing?
No one.
Make an attempt in that way also. I understand.
We'll attempt that.
Please do that.
Please.
Learned government advocate also undertakes to serve notice on the learned counsel appearing in the tribunal and submits that there is an urgent need for an interim order in view of the fact that the contempt application is pending when?
My lord, it's today, my lord. In fact, I mentioned yesterday for being posted at the end of the list, but it could not
Yes.
be taken place.
In the above view of the matter, awaiting service of notice to the respondents. Further proceedings in the contempt will not be precipitated till the next date of hearing.
Grateful.
Sixty-five.
Kindly have it after vacation.
Only translation,
Yes, ma'am.
usual orders in the translation, only whatever is relevant, please make it
Yes,
after all this. Yes.
66.
Petitioner, my lords, plus translation, my lords, and typed copies, my lords. Relevant documents of typed copies I have already produced, my lords.
Yes. Orders. Usual orders in the translation list after.
Please, ma'am.
67. Sunil Kumar BN.
Waiting for the applicant's counsel. This matter, my lords, have heard for some time. This is a premature transfer. Lord, I have given the
Is this immediately after holidays?
till then, my lord, let them not disturb me, my lord. I am still working there. I have not handed over the charge. But whereas, my lord, the respondent got himself relieved and, my lord, he is there, but I have not handed over the charge.
Pass over. Let us make an attempt.
Please.
They have filed against the interim order and your lordship did not grant them an interim order.
And what happened there?
That is the final.
Dismissed. And against, it is dismissed against which present writ is filed. Order is.
That has become infructuous. This is an order which is called in question now.
We'll see either.
Very good.
Yes.
I'll come back to you.
68.
68. Amritesh.
I've served a copy on the Lokaयुcta Council, my lord, Prasanna Shetty. My lord, on last day of hearing PS
It's
Rajagopal,
not shown.
I filed a memo to that effect, my lord.
Yes, please show with me.
My lord, may I request for a date after immediately after vacation?
Immediately.
In the preliminary hearing, my lord, because on the last date, your lordships had asked the government to ascertain it. Deeply obligements.
Sixty-nine. Power Prakash.
Is there, if there is no extreme urgency, can we
The
have to-
extreme urgency is this, that the department is before the court.
Hmm.
We are thrusted upon a person whom this honorable court has held is not eligible to come to this post.
Not so, your lordship.
I will.
The tribunal, and more importantly, if
Has court fee been paid?
Yes, my lords.
Effective court fee has been made good?
Court fees is made good. Court fees ಕೊಟ್ಟಿದ್ದಲ್ಲ? ಹಾ.
Will be listed on Monday. How many are there? Hmm? Tuesday.
Very well, my lords.
Let's take the Passover.
Passed on matters. 6. Number 6, Government Advocate.
Two things.
Issues only that.
Issue is only that, my lords. I'm not arguing the matter that way, my lord, just giving a facts because we are seeking for final disposal in this matter.
Correct.
So just for the sake of context, my lords.
Please tell us the numbers of the writ petitions or the, that you're referring to.
WP
Please.
10771 of 23 was filed by me, my lord. That is,
WP 1,
10771 of 23 is filed by Sri Lakshmi, my lord.
yes, you were the person who were, you had applied pursuant to the 2002 notification.
Two notification.
Mm.
And my name was there in the additional list.
Mm.
Instead of operating the additional list, my lord, they proceeded
Correct.
to.
Correct.
issue a fresh notification. But that fresh, the appointment of the Srimati Savitri was challenged.
Just a moment. Fresh notification is on.
But fresh notification is on
24/5/2011.
24/5/2011.
Hmm.
But the
Correct.
first notification was 29/11/2002.
Hmm.
Now, my lord, in the meantime, my lord, the select list itself was challenged in application 2739 of 2003.
Hmm.
My lord, by one TC Parvati.
Hmm.
My lord,
Parvati.
TC Parvati. That is, she was, my lord, she had challenged the inclusion of one Ansuya in the list. She approached the tribunal, my lord, challenging the final select list and non-inclusion of her name.
Hmm.
But subsequently, both Ansuya and my lord Parvati were appointed as Gram Panchayat secretaries. They, my lord, they were not interested in pursuing the matter. Thereafter, my lord, I made a representation requesting to operate the additional list in view of the application having become infructuous. But that representation was, during the pendency of that representation, my lord, a second notification was issued on 24/5/2011.
You had filed application number 6191 of
2011.
To operate the additional list.
Yes, ma'am. But in the meantime, on 24/5/2011, the fresh notification was issued and Srimati Savitri was appointed. Sumitra was appointed.
Yes.
Appointment of Sumitra was made subject to pending application, my application 6191 of 2011.
Sumitra's appointment was on
13/7/2012. 13/7/2012. But even the appointment of Sumitra was also challenged in 7714 of 2013.
appointment of Sumitra was subject to result of 6191
6191 and subsequently, my lord, one more application was filed
by
Parvati 7714 of 2013 challenging the appointment of Sumitra. On 6/12/2017, the application was disposed of directing to
your application.
yes,
Six.
was disposed of directing to consider my representation. But considering the representation of obtaining DPR, this one, my lord, what they did was they cancelled the appointment of the Sumitra as well as, my lord, no, two orders.
Cancel the notification as well as the appointment.
No, not notification. Lord, that is, no, 1 second, my lord. Lord, your lordship may kindly see. Lord, 21/12/2018, my lord, the third respondent was
Withdrew the appointment.
withdrew the appointment.
Hmm.
And my lord, she was relieved on 22/12/2018.
Hmm.
Those two orders were challenged. Lord, I was appointed on 24/12/2018.
Hmm.
My appointment order was never challenged by the secretary.
Therefore, all this was simultaneous. The appointment was withdrawn. She was sent out of service and you were appointed. It is at that stage she approached the tribunal. Yes.
Please, Milords.
Yes.
Milords, just two more dates in that. Milords.
Mm.
Milords, the main notification on the basis of which Milords,
Mm.
Sri Lakshmi is claiming right is 29/11/2002.
Mm.
Then, Milords, the final select list is dated 28/2/2003. This may be noted, Milords.
Final list is 28
to 2003.
2003.
One Anusuya Talwar
Correct.
name is there in the list. This was challenged, my lords, in 2003, application number 2739 of 2003. My lords have noted it already. My lords, this challenge, it was found, my lords, that the petitioner therein, Parvati, was more meritorious because of her rejection of her candidature was set aside, and court quashed the selection of Anusuya Talwar, directed appointment of Parvati, and it was also noticed therein that during the pendency, no appointment order was issued to Anusuya Talwar on that ground. Now, thereafter, my lords, kindly note the date 15/2/2010 is the disposal of that petition.
Yes.
Now, therefore, my lords, afterwards, the next recruitment notification, then, my lords, Parvati's vacancy, Parvati did not take up the appointment. So when the next notification is 24/5/2011. So immediately thereon, my lords, that a vacancy was released for fresh recruitment. Thereafter, my lords, the disposal of the application of 6191 of 2011 is on 6/12/2017. Though the appointment order, my lords, is subject to, but the disposal, it merely has said, consider the representation dated 26/9/2008 for operation of the additional select list. Now, additional select list, her name was placed in the additional select list. Plus, there will be a time limit, even otherwise reasonable time. It cannot be operated once. Even, my lords, it cannot be operated, my lords, it cannot just be held that the additional select list is valid or in currency, my lords, for an unreasonable length of time. 2011, but still, my lords, the fact that that vacancy itself was included in the subsequent notification, I think that should be the end of that, technically the additional select list. But any which way, 2017, when application number 6191 of 2011 was allowed, court did not direct appointment as against that operating that additional list, but directed consideration of a representation.
And
now that is where
consideration, what happened was that she was the earlier list and the earlier appointment was recalled and she was given appointment.
That is where, my lords, that is what I'm saying. So therefore, in my respectful submission as an officer of the court, these are the facts. And my lords, maybe the state itself, the fact that we operate now, the fact that I allowed somebody to come in operating a very old additional list, my lords, which according to me would have lost currency as an officer of the court, whether what the department. Now, my lords, therefore, my submission would be is, we had in fact not challenged the order passed by the tribunal. And my lords, only when we were, it was in the contempt stage, when even a fine of 1 lakh was imposed on us, at that stage we had to rush to this honorable court because there was an order. In the review application that was filed by Sri Lakshmi, all that they say is, I have been working. I have been kindly save my appointment. That is what the review petition said. Review application is dismissed. So therefore, my submission would be that the appointment of Sumitra, my lords, seems to be valid. Appointment of Sumitra, my lords, seems to be valid.
Just what we said yesterday.
Please, my lords. Now, only thing is how, when supernumerary.
It is not as if the tribunal had directed the appointment of Sri Lakshmi.
Lords,
Tribunal had only directed the consideration. You
and
took up the matter for consideration. You pass an order appointing her, cancelling the appointment of the person who's already been appointed. She cannot be left out. And
now that we ourselves, my lords, have given an appointment order and she has been working. So therefore, my lords, the solution, we were even on the earlier date, not yesterday, my lords, even on the previous date of hearing, we were trying to find a solution. The only thing was, my lords, supernumerary post came up. Then there was
supernumerary need not be.
No,
however it is, now the only way out of this, this person who has been appointed subsequently after undergoing a due selection process must also be
appointed. What I would, my submission would be that both writ petitions, the state's writ petition, my lords, I'm making the submission, my lords, it should not be that I'm asking for dismissal of my writ petition also.
I understand.
I'm just making the submission, my lords, as an officer of the court. If both the writ petitions are dismissed, then, my lords, the order has to be operated. Then automatically, my lords, she will get reinstated. And court also, my lords, court also has said, my lords, since it was, my lords were passing an interim order, I didn't want my lords to pass an interim order because tomorrow again it should not create any complication for another 5 after 1 year if it's going to be disposed of. So I just wanted to get it disposed of, my lords. Now, so she will be back in service, and whatever order the court has given with regard to other benefits, my lords, will stand. Tribunal. Now, in so far as Sri Lakshmi is concerned, my lords, I have verified there is no backlog vacancies as of now. But in the department, my lords, as on today, in the second division assistant cadre, we have, my lords, around 168 vacancies that are there. So, my lords, in the next round of recruitment, we will obviously be operating the roster points. So, she has been appointed as against the ST woman category, and both of them ST women. That was a backlog. Now, my lords, if my lords say that the department should consider the appointment of the petitioner in the connected matter as against one existing vacancy, and in the future recruitment, it should be adjusted as with the first ST roster point, so that, my lords, there is no issue there, and the department, my lords, also need not have to go for additional concurrences with the social welfare department, creating complications.
May I submit, my lord? Lord, admittedly, my lord, my appointment is pursuant to first notification. Lord, the tribunal fell in error in not noticing that there should be an additional list. Lord, your lordship may kindly see the amended rule was not considered, was not placed before the tribunal when this kind of an order was passed. Lordship may kindly see
Yes.
the rules that were amended.
Yes.
Page 7, my lord. This is the special recruitment rules. Lord, these were published in 2010, my lord. The amendment, your lordship may kindly come to page 7, my lord. Lord, page 6, my lord, rule 6 relates to method of recruitment, that is list of selected candidates. Lord, your lordship may kindly come to page 7. Lord, clause 3 and 4 were inserted in 2002. Lord, clause 3 reads, the selecting authority shall, in accordance with the provisions of sub-rule 1, also prepare an additional list of the names of candidates not included in the list prepared under sub-rule 1, in which the number of candidates to be included shall be equal to number of vacancies notified. Next, my lord, the list prepared in accordance with sub-rule 3 shall be published in the official gazette. The candidates whose names are included in the list prepared under sub-rule 3 may be similarly appointed only in case to the extent the candidates whose names are included in the list prepared under sub-rule 1 and to whom order of appointment has been issued to not to assume charge of the post to which they are appointed by appointing authority within the joining period of time. Therefore, my lord, this list ought to have been operated till the posts are filled up. But this was not within the knowledge of the tribunal, Lord. It was not placed before the tribunal. Lordship may kindly come to the order of the tribunal. Tribunal presumes that there is no provision for preparing the additional list. In the absence of any provision for preparation of additional list, question of operating the additional list doesn't arise. But there is a specific provision under the rules that it is mandatory to prepare an additional list and to operate it till all the posts are filled up. Lord, therefore, my lord, the issue of the second notification is, my lord, contrary to the 2001 rules, special recruitment rules. And accordingly, my lord, I have been appointed to the post which was notified in 2002 and by operating the additional list in accordance with law. Therefore, my lord, my claim cannot be rejected by the.
Yes.
What is challenge? In that he has challenged by notification of 2011
Also,
he challenged there, given of the prayer.
we understand the contention. Let us pass the order now.
Please.
For this aspect, you've all been arguing for 2 days, please.
Now there is a solution. Please, let's.
Yes. In the future, recruitment, the appointment can be adjusted as against?
Please,
Yes.
as against ST vacancy, ST roster point.
ST one.
ST roster point.
ST roster point.
Heard the learned counsel appearing for the petitioner in WP number 10771 of 2023. The learned first heard the learned additional advocate general appearing for the government in WP so and so. Learned counsel appearing for the petitioner in WP 10771 of 2023, as well as the learned counsel appearing for the respondent in the state's writ petition. The issue raised in these writ petitions is with regard to selection and appointment to the post of STA in a vacancy, in a backlog vacancy of scheduled tribe women. Backlog vacancy kept apart for scheduled tribe women candidates. It is submitted that the initial selection for the backlog vacancies was notified on 29/11/2002. Full stop. The final select list was issued on 28/2/2003, where the name of one Anasuya A. Talwar was included in the list. One candidate in the selection, Srimati Parvati, filed application number 2739 of 2003, challenging the final select list and the inclusion of Anasuya Talwar therein. It is submitted that during the pendency of the application, both Anasuya and Parvati were appointed as Gram Panchayat Secretary Grade 1 in other selections. The tribunal on 15/2/2010 allowed application number 2739 of 2003 and quashed the final list dated 28/2/2003, as well as the selection and appointment of Anasuya, and directed the consideration of appointment of Parvati to the vacant post.
Directed appointment itself.
There,
Directed appointment itself.
directed appointment of Parvati to the said post, to the vacant post. It is submitted that on 24/5/2011, without on noticing that neither Anasuya nor Parvati were available for appointment, a fresh notification was issued to fill up ST backlog vacancies on 24/5/2011. In the meanwhile, on 18/8/2011, the petitioner in WP 10771 of 2023 approached the tribunal, filing application number 6191, seeking the preparation of an additional list and preparation of the additional list.
Operation of addition.
The additional list was
Was
already.
already there.
Seeking the operation of an additional list, which was published pursuant to the notification dated 29/11/2002. In the meanwhile, the respondent in the application, she's a respondent in both the applications.
Yes, in my application, she is a writ petition third respondent.
The respondent, the private respondent in the applications was appointed as SDA pursuant to the notification dated 24/5/2011 on 28/3/2012. While so, application 6191 was disposed of on 6/12/2017 with a direction to the respondents to consider the representation of the applicant therein. That is the petitioner in WP 10771 of 2023, in accordance with law, within 2 months. The second respondent considered the representation, withdrew the appointment of the third respondent, and appointed the petitioner on 24/12/2018. The third respondent challenged the same before the tribunal, filing application number 3930 of 2019.
No, she did not challenge my appointment number.
3930 of 2019, full stop. The tribunal considered the said application and found that since the applicant therein, that is the party respondent in these writ petitions, was appointed after appointed pursuant to the notification dated 24/5/2011. After undergoing a due process of selection, her appointment could not be disturbed. The tribunal therefore directed what is the order?
My lord, set aside the two orders, my lord, 21/12/18 and 22/12/2018. And my lord, directed reinstatement within 3 months. my lord.
The learned, the tribunal set aside the orders which were under challenge in the application and directed the reinstatement of the applicant therein within 3 months. The state is in challenge against the said direction. The state is in challenge?
No,
No.
my lord,
They are
in the
It is in
mean,
challenge against that direction.
We are in challenge
Yes, against,
against the main order, but it was only when the contempt was
contempt was
precipitated,
filed.
yes,
because there was an interim.
But in the
order
meantime, my lord, I had filed a review petition
yes.
before the tribunal, my lord, specifically requesting that they should not disturb my appointment because there is no direction, no prayer for cancellation of my appointment.
So and so, the applicant, the petitioner in WP 10771 of 23 filed a review application number 5 of 2023 seeking review of the order in application 3930 of 2019, seeking a direction not to disturb her and stating that she has no objection
For accommodating third respondent.
for
Yes, ma'am.
appointing the third respondent against a backlog vacancy.
Not for the review of the order.
Yes,
Don't make it.
That was not the prayer, just see the prayer.
in the, just a moment, counsel, please. It is submitted that when the orders passed by the tribunal in 3930 of 2019 were not complied with, the applicant had preferred a contempt of court case
Statement.
and
State has-
applicant had preferred a contempt of
Contempt.
court case. And as against the orders passed in the contempt and in the main application 3930 of 2019, the state is in challenge before this court. Having considered the contentions advanced on all sides, we notice that the private respondent in these writ petitions is a person who had been appointed against a backlog vacancy in terms of a notification issued by the state on 24/5/2011. The application filed by the petitioner in WP 10771 of 2023 had been disposed of on 6/12/2017 with a direction for a consideration of her representation, pursuant to which orders had been passed cancelling the appointment of the party respondent and appointing the petitioner as against the same post. Though various contentions are raised on behalf of the petitioners in both these writ petitions, we have no doubt in our mind that a person who had been appointed pursuant to a notification issued on 24/5/2011 and after facing the process of selection cannot be kept out of service. And the appointment made could not have been cancelled for accommodating the petitioner in WP 10771 of 2023 or for any other reason. In the above view of the matter, we are of the opinion that the writ petition filed by the state cannot succeed since the directions issued by the tribunal cannot be found fault with. The above view of the matter, the writ petitions filed challenging the orders passed by the tribunal in the applications filed by the private respondent herein shall stand dismissed. However, there'll be a direction to the, however, in view of the fact that there are 168 vacancies of SDA available as on today, there'll be a direction that the petitioner in WP 10771 of 2023 shall, the appointment of the petitioner in WP 10771 of 2023 shall be adjusted against one such vacancy with the condition that in future recruitment, the appointment shall be adjusted as against ST roster point. These observations, the directions. Yes, what about you? Within time. Yes, the learned, the respondent, the private respondent shall be reappointed
Short.
and with what time?
Let's 15 days from the date of the receipt of the certified copy.
Within 15 days from date of 15 days from date of receipt of a certified copy of the judgment.
Please.
And will be entitled to all attendant benefits.
What? No, court no ಅಷ್ಟೇ. Receipt is whether I take it or you take it. Please.
Yes.
He's saying that he will give the certified copy earlier. I said, please give.
Certified copy, now it
is-
is uploaded. There is no.
But my appointment would be adjusted against another vacancy, right?
Yes.
Grateful.
State's application is dismissed. The other one disposed with directions.
My lords have said in the future recruitment, it should be in the
Correct.
future vacancies. Future recruitment means we have to start the recruitment. While filling up the next thing, before the recruitment itself, we adjust it. Since ST is filled, we don't release it for recruitment. That is how it has to be. My lords have used the word
As against future ST vacancy.
ST.
As against
Yes, future
adjusted as against future ST vacancy.
roster vacancy, please.
It will drive me.
If we say recruitment, it will be a
Please, because
Difficulty.
vacancy, my lords.
future ST vacancy. Yes.
Grateful.
24, Karumbaya.
I am a tenant, my lord, and I am seeking some time. And I am seeking time.
Some time is all right.
That's all. my-
But
that's
you had sought 1 week's time there and you came here and even now the amounts have not been
No, that is,
paid.
the amount I have paid. That
Amount has been paid.
Deposited as directed.
Please agree as to the
No,
time.
that is what I requested till December, my lord, because she has to, from the past 23 years, she is
Can
carrying.
it be? Subject to your, no, it is between you, not,
That is the
not
request
our,
of my brother.
no order is being passed. If you agree, that will be recorded.
It is a lie, all this.
The appeal is for grant for 1 year of time. They've already taken 9 months.
No, no, no. Okay.
Agree to 2 months. Yes. Heard both sides. The learned counsel appearing for the respondent submits that the appellant had, as a matter of fact, agreed to hand over vacant possession of the property in question within a week before the executing court and had thereafter approached this court stating that proper time had not been granted by the executing court. The order sheet of the proceedings in execution is also made available. The learned counsel appearing for the appellant submits that all that was sought for, all that is sought for by the appellant is some breathing time to vacate the premises. Having heard the counsel on both sides, and in view of the submission made by the learned counsel for the appellant, that the property will be vacated within 2 months' time. He said undertaking is recorded, and yes, what about the balance?
That I will pay, well. Whatever the arrears,
Said undertaking
apart
is
from the-
recorded. Yes.
yes, yes.
Yes, they said undertaking is recorded, the respondents, the appellants shall place on record an affidavit undertaking to vacate the premises in 2 months from today, as also with regard to payment of the balance amounts due as rent and arrears as decreed by the court.
Honor before 30th of November, my lord. No, honor before 30th of November.
Before 30th of November. Yes, please make the
Yes, please.
affidavit.
Affidavit within 2 weeks, my lord, by vacation.
Yes.
Yeah.
The affidavit shall be placed on record within 2 weeks, and the parties shall abide by the terms thereof.
Please.
Yes. 14%.
Orders number 50, Krishnamurthy, party in person.
Notes are there.
My lord, some records as filed by the respondent, those records has been, those copies have not been served to me.
What are the records that you have not received?
But in the last occasion, the honorable court has directed to produce the inquiry report and other necessary documents. But he
They've been
filed,
filed?
but those, he filed some documents before the court, but those documents has not supplied to me, except he sent one letter. One
Yes.
letter. There is only a copies of Saukash
Have not been served on him.
My lord,
The inquiry report and some records have not been served
my
on
lord,
him.
inquiry reports and in findings, it was served in the presence of the court, in the presence of the court on 15/4. My lord, what happened, my lord? It was now that petitioner said I have not received. Then I submitted before the honorable court, stating that we have sent by post, but all returned. Then he said, today you give. So on 15/4, in the open court, inquiry officer report and all, it was handed over to him. But now also, my lord, and it was handed over to petitioner. So all these documents, my lord, it was with the petitioner. Even now it is petitioner because it's handed over in the court hall only. Now on that day, my lord, your lordship, after hearing the arguments regarding that whether charges are vague and all these things, entire matter was discussed. Then your lordship said, please produce the document to show that allegation has been served on him. So my lord, I prepared this one copy also I'll give my lord of petition.
The difficulty is that if when copies are being served like this, there will be no record that it has been served. If it is
And this-
filed, if it is filed in the registry, then the service will be clear. It
No,
is by-
again, that's correct, man. Because to file in the registry, you have to send it by registered post. So 3 documents which he denied, that documents are sent by post, and we got the acknowledgement and we filed in the office. That is before this court now. But these other 3 documents, my lord, there only I mentioned, all these documents have been given in the court and all, I have mentioned that. But now he says, no, that is, but now I'll give my lord.
Yes,
I'll hand
please
it-
record. What are the documents? that are being
See,
served?
this is the document, my lord.
Which is, there is a memo, it is with the memo?
Yes, with the memo.
Yes,
My lord, on submission.
accept the memo and say that it has been served.
Sir,
Please record that memo dated so-and-so with documents served in court on this day. It has been accepted by the party in person. Yes,
My lord, even though rejoinder has been submitted based on availability of records with my side. But my submission is restricted only for pleading, grounds and prayer of the admitted writ appeal and prayer of the writ petition with IAS.
you want further time to,
No, I'll finish
Don't
only 8 minutes. Whatever I wanted to say, everything has been
Is it-
stated in
is
the
it good?
written argument and also rejoinder.
but now you say that the documents that you have received, you're already in possession of these documents. you're
Already
aware-
rejoinder has been submitted, my lord, because these document, I think, whatever he filed, I don't know.
Oh
But
my
now he
God.
has served to me, but already rejoinder has been, no,
Yes.
yes, second, my lord. I'll submit only few minutes. My submission is this. I'm not, I'm very much interested only my pleading, grounds and prayer of the admitted writ appeal and prayer of the writ petition, IAS, to ascertain the dispute and narrow the real,
As
narrow
far
the
as we
real
are concerned,
conflict.
we have to hear the other side also. We cannot decide on your
I
arguments
already
alone.
given, even
Yes.
rejoinder
Therefore-
also submitted there and also it has been recorded.
Yes, list after holidays, we'll hear it.
My lord, एक second, my lord.
Council,
I'm not going to
we
take
don't
much
have
time.
this kind of time. We are sorry.
My lord, I'll finish only because this is the main argument, my lord. Even whatever I made a submission, that is entirely different pertaining to the
My lord,
admission of the writ appeal.
I was continuing the
here is-
argument. My argument is not over now.
Here is important. This is the proceeding only is going on, my lord.
Please, we have heard you. We are proceeding to hear the other side.
Yes, ma'am.
That was what was going on in the last date. If this is the kind of argument that is going on, we are not interested. We cannot accommodate you when the court is going to close and there are senior counsel waiting for audience in some matters. This cannot go on like this. List it after holidays. Yes. Because you are coming in person, we are trying to
My lord,
accommodate
it is
you.
my humble request because already I submitted a written.
We have to hear the other side, counsel.
Kindly make it at least part on, my lord. Because my argument is for,
Yes.
25, 9, 10.
my lord, it is my humble request, kindly make it part on.
Cannot be made part heard, counsel. That,
My lord,
I mean,
My lord, already.
it
my-
cannot be made part heard because
Lord,
this.
it is a 28 years old matter, 6th round litigation on the same fact, same.
Yes.
Sir, kindly make it part on, my lord.
Passed on matter 67. Sunil Kumar.
Yes.
First ground of challenge, my lord, it's a premature transfer. Your lordship will kindly note the date, my lord. The date on which, my lord, I was transferred to the present close posting, my lord, on 7/9/2022. Lord, I reported for duty, my lord, on 11/10/2022.
What is the post? RFO.
RFO. My lord, the impugned order of transfer, my lord, is dated 31/7/2022. The fixed tenure for the post is 2 years. Therefore, my lord, having regard to the dates that I have given, my lord, it clearly indicates, my lord, that it is before 2 years, my lord, this impugned order of transfer is made. But the division bench of this honorable court, my lord, had an occasion to consider, where my learned friend was also there. Consider, my lord, the effect of new transfer guidelines. Operative portion, my lord, the conclusion of this order, my lord, will clearly indicate that the transfer guideline are enforceable. They have force of law. Page 24, my lord, last conclusion.
Yes.
Lord, paragraph 2, my lord, in the conclusion. The government servant is protected with a minimum tenure of posting under clause 6 of the government order dated so and so in case of deployment also. My lord, it was a case of deployment and transfer, my lord. The court have held, my lord, the transfer guidelines applicable for both. My lord, we are not concerned with the deployment or transfer. My lord, it has been stated, my lord, the rule 6, my lord, protects the tenure. If that is the case, my lord, the admitted position is, my lord, I have been transferred, my lord, before 2 years. Before the expiry of 2 years. And it is made to appear that it is a general transfer. In any event, my lord, even if it is a general transfer, I was not available for transfer, my lord, under the impugned. Unless I complete, my lord, 2 years, the officer will not be available for transfer.
The new guidelines say that minimum period of service
2 years.
may be extended or reduced in the following circumstances. where a
None of the
government servant-
circumstances under Rule 7, my lord, your lordship will kindly see the Rule 7. It enumerates, my lord, the reason for
Where he is less than 2 years for retirement, then.
none of
there's
the
a special
none of the
qualification.
reasons mentioned in Rule 7, my lord. Your lordship have, my lord, the copy of the.
Yes, it's
Not-
there in the judgment.
Yes, yes,
It's extracted in the judgment.
yes.
Hmm.
My lord, none of the clauses mentioned in this guideline, my lord, are available, my lord, to point out that the, in exercise of that, my lord, that they can sustain, my lord, the order of transfer. The tribunal, your lordship will kindly see. The reasoning assigned, my lord, absolutely no discussion, my lord, on this question, my lord. Para 9 at page 19, your lordship will kindly. Last 2 lines, my lord. Such contention forwarded by learned counsel for the applicant does not hold water. It was in relation to premature transfer. The old guidelines have been, my lord, one of the contention it was raised, my lord, that no reasons have been assigned so as to see whether there is a compliance of Rule 7. For that, the tribunal says the old rule is no longer there. Therefore, that contention cannot be accepted. In 2 lines, such a contention forwarded by the learned counsel for the application does not hold water.
Which is the order of transfer?
My lord, the impugned order of transfer.
Relevant.
Page 65, my lord, my name finds at serial number 160. 65.
65 is the
English, my lord, it's translated, my lord.
Yes.
My name appears at serial number 160.
This is on 31/7/24.
Lordships have seen, my lord, timing mentioned in that I have brought to my lord's notice. Timing.
Yes, sir.
Just to make it appear that it has been done within the cutoff date. They have extended 1 month time for general transfer.
Yes.
Lordship find, my lord, the last portion of that order. At page 60, my lord, the timing, if my lords want to see. Page 60. 23 hours, 57 minutes, 51 seconds.
Now you were transferred from where to where?
From Shivamogga to now, Lord, Kolar. It's about 400 kilometers. The another ground, my lord, urge was, my lord, the petitioner wife is undergoing some
69.
treatment for HIV. I'm sorry, my lord, IVA. Therefore, she needs constant consultation with the doctor. In that context, my lord, I made a representation, my lord, to the officer, my lord, that is my range forest officer, chief conservator of forest, my lord. I made a representation, my lord, that so far no order is passed, my lord. I took
Yes.
time, my lord, with a request, my lord, to make a representation to, my lord, the conservator of forest. My lord, so far, my lord, no orders are passed, my lord. To retain me, my lord, in the said post, my lord, for another 8 months of time.
Yes. Where is the private respondent? He's been called away.
Called to an
Yes, what do you say?
but it's a general transfer and the same stringent conditions relating to supplying of reasons are not there in the new guidelines.
Hmm.
It's only my representation, my lord, to retain me in that post.
After partly hearing the matter, the Honorable High Court has orally directed to give memorandum to retain the undersigned. Yes. No, the situation is that the other person is actually joined and is working.
He has come there. I have not handed over the charge.
How can you not hand over the charge when there is
Lord,
a...
there is a procedure prescribed, my lord, the one has
Yes,
to
how
hand over.
can you not hand over the charge when there is a direction?
Lord, because I am before the court, my lord.
That-
I've been making, my lord, even I have filed a writ petition when no interim order was considered by the tribunal. And thereafter, my lord, it was posted on 26th, my lord. I was asked to go there before the tribunal and find out what final order could be made, my lord. It was in this process, my lord, he is holding on there, my lord, and he is discharging the duties. Insofar it relates to, my lord, the person whom I am going to disturb, that person is waiting for posting.
Is there any other matter? No, nothing? That is all. Any other matter today? Because the other side is not there. Yes. Hmm. Okay. What do you say?
Government has to consider, take a call on it.
That can be directed. Directed, that will be considered.
I don't know what is written in his representation.
Serve a copy. He's not written anything in his representation.
Just to retain me in that post.
Petitioner has virtually completed. All these contentions raised before tribunal are being rejected. Proper finding. Not a blanket or can request for Monday.
Please go and join the place. We'll direct that this will be considered.
That
Will be
becomes,
the end of it.
well, matter becomes infractuous, my lord.
Not. It will not. Because this.
But if I go there, my lord, the person who is now serving in that place where I am now posted, she will be disturbed. And if she is disturbed, my lord, she is without any posting. Either in either circumstance, my lord, one post, my lord, there is no posting.
Let it be considered on the merits. Let it be considered on the merits. Heard the learned senior counsel appearing for the petitioner, the learned government advocate, as well as the learned counsel appearing for the private respondent. It is submitted by the learned counsel for the learned senior counsel appearing for the petitioner that the petitioner had been posted at his present place only on 7/9/2022. And the transfer order passed on 31/7/2024 was therefore premature. It is submitted that no reasons are stated for disturbing the petitioner. It is further submitted that pointing out the reasons for seeking a continuance of the same post, the petitioner has approached the respondent. Which respondent? First-
Conservator of forest.
Has approached the
Respond number 2, my lord.
second respondent with the representation dated 13/9/2024, which may be directed to be considered on its merits. The learned counsel, the learned government advocate submits that the order passed was an order of general transfer within the transfer period, and therefore the contentions raised are untenable. The learned counsel appearing for the private respondent submits that the private respondent has already assumed charge at the transferred place, full stop. Having considered the contentions advanced and in view of the representation submitted by the petitioner seeking continuance, we are of the opinion that it is said representation is liable to be considered in accordance with law. The second respondent shall take up the representation submitted by the petitioner and consider and pass orders on the same in accordance with law within 3 weeks.
Retaining him in place.
You've not stated anything.
But he would have made a representation to retain.
Correct.
If that is considered, then 6 other officers in that phase only will have to be moved out.
Let it be considered on its merits. He's made a request. He says now it is not with regard to anything else, but some personal grounds that he's raising.
Any other person nearby?
Or,
No, my lord, for him, any other person, but if there is retained, I will have to go back to the earlier date, which means the person who is posted to my well.
we've not said anything about, we've also said that it's a general transfer. Yes.
Sorry. Father was admitted, therefore I had to take that one. I'm sorry, that you have to put it.
It's okay.
Okay. See.
B group continuation, till number 27, K Ravi Shankar.
B group, can we list matters on some other day? What is the urgency for today? We list this immediately after holidays. Monday or Tuesday cannot be, sorry. Yes, list matters. Someday there are so many orders to be signed.
My lord. Finally, matter 76. My lord, serial number 34, my lord. Interim order, kindly extend the interim.
All the interim orders will stand extended till the next date of hearing.
Please.
Yes. If we hear matters now, it is going to be difficult. Yes. Immediately after. Yes, unless there is some pressing urgency, we cannot list matters on Monday or Tuesday. There's no point, it may not reach.